Waiting on y'all.
And we were just talking, waiting on y'all.
Hi, Judge. Is the state there?
Sorry? Yes, it's already logged on.
Oh, I logged in for you, Judge. Don't worry.
Okay. I hear all these voices, I'm not sure the system.
Oh, I'm sorry, Judge. I'm on Zoom.
Okay.
Hi.
Oh, there you go.
Hi. Okay. So this Zoom works a little differently than the one you just saw in 4.1. This one is a webinar. I'm not sure if you fully know what that means, but that's fine. Essentially, the short, sweet version of it. Most people cannot turn on their microphone, nor their camera, nor share their screen. We can because we are panelists.
Okay.
If somebody wishes to become a panelist from the attendee side, they have to tell us in the chat or the Q&A function. And if their information is legitimate, we let them in.
Okay.
So typically I don't let in bail bond companies or iPhones or Samsungs, anybody with a device name, I don't let them in. Okay, there was another thing. What was the other thing? Oh, right. How much do you want me to do on Zoom? Like, do you want me to just do everything on Zoom for you, or do you want me to be hands off?
No, you can do everything.
Understood. Let me see, what else? Oh yes, this is more for the state than for the judge. I would politely ask that since the record cannot see you, as I am compromised, please clearly enunciate your name for the record. And speak clearly into the microphone. That was a problem last weekend, that we couldn't clearly hear the state. So just be in close proximity to the microphone if possible.
I will try my best.
Thank you. I really appreciate it. Oh, and Judge, we're ready to begin when you are.
Okay. Madam Clerk, the I guess pre-trial for DV, the stay away orders and everything. Oh, you have them all for me? Okay. No. As far as signing up for the public calls and everything, I sign it here, where?
You would write right here next to the date, whatever, you know, set profit calls and the bond amount. And then, here is the orders. So just initial wherever it applies and any for where it doesn't apply.
And is the parties gonna be here?
It would be on Zoom.
Okay.
And I mean, we don't get the financials until after, so the PD is appointed.
Good.
Do you want me to hand you the cases one by one, or would you prefer everything together?
You gonna call them in order or?
You would want me to call them, I can call them.
Okay. I guess this was the first, right, this is the first one, Sophie Oriental. Yes. Yep. Just make sure I sign everything in the right spot. You have my stamp, right?
Yes, sir.
Okay. All right, so if we're ready, I guess we can proceed. We're on the record.
Recording in progress.
Good morning, Your Honor. Are you ready to swear in inmates?
They're there. We don't have a camera, Judge, so are they there?
Yeah, I mean, we are ready. We can't see, I guess, the inmates, but if you,
One moment, Your Honor.
okay.
All around, everybody stand up, raise your right hand, stand up.
Todo el mundo de pie, levante la mano derecha. Todos de pie, levanten la mano derecha.
Raise your right hand.
Levanten la mano derecha.
Do you solemnly swear or affirm that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth? If so, please say I do.
Uno prometen que el testimonio que van a presentar va a ser la verdad, solamente la verdad, de ser así, digan que sí.
Lo juro. No habla inglés, lo juro. Dígalo, lo juro. Have a seat, gentlemen, have a seat, ladies.
Pueden tomar asiento.
Calling the case of Oriental Sophie, M25-17191.
All right, I think the defendant is present. Counsel, you unmute yourself. I can't hear counsel for the defendant.
Your Honor, this is video. I believe the issue is that they are muted on Zoom.
But I mean, how can I, if they're representing the client, okay.
Good morning, Your Honor. Can you hear me?
I can hear you now. Thank you. Good morning.
Good morning, Your Honor. Assistant Public Defender Tamara Gilbert on Ms. Oriental's behalf. I was just wondering, Your Honor, are you going to provisionally appoint the public defenders on all of these cases?
Yes.
Thank you, Your Honor.
All right. State.
Morning, Your Honor. ASA Corinna Mita on behalf of the state. In the case of Miss Oriental, the state would be asking for a bond of $1,000 to be set.
Defense, any argument?
Your Honor, I would just argue that this is Miss Oriental's first offense, and so I would be asking if PTS would be an option.
All right, she does qualify. I do find probable cause. She can be released to pretrial. So Miss Oriental, I found probable cause. You will probably be released in a while to pretrial, but there's some other conditions of your release that I must go over with you. If and when you are released, you cannot engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. If you own such property, you must immediately surrender any firearm, ammunition, and any concealed weapon permit to the nearest police station and file a receipt with the court. You are prohibited from having any direct or indirect contact with the following person here, the victim in this case, JF, including contact in person, in writing, by telephone, through social media, or through third persons. Defendant must stay at least 500 feet from the victim's home, place of employment, and or school at all times. I did read in there that the parties were married. Okay, so find the protected party as a spouse. Didn't say whether they had any children in common.
They have one shared child in common.
Okay. All right, so the defendant may return to the victim's residence one time only within 48 hours of the entry of this order, be accompanied by a police officer to retrieve his or her personal clothing, personal health items, medication, personal and business-related paperwork, and work tools. going to the home or remaining at the home without the police will subject the defendant to arrest. The police officer shall request all keys and garage door openers to the home from the defendant and turn them over to the victim. The I'm not, are they asking for any contact? They are married?
We would have to know.
All right. The defendant is allowed to have contact with the victim, but is prohibited from being physically threatening or violent toward the victim in any manner whatsoever. In the event that the victim in the above captioned case, well, is not. All right, so this last one does not apply. All right,
Your Honor, it's pretrial alternate 1,000.
yes. Yeah. All right, did I sign everything right?
The last one doesn't look like just put any.
I thought I was facing the computer or something.
Signature or initial? All right, the next one is I guess Brittany Avila.
Yes, Your Honor, she's present.
Okay, good morning.
Good morning.
It states.
Yes, Your Honor, in this case, the state would be asking for standing file.
All right, give me a moment. Let me read the A form. All right, defense, any argument in reference to probable cause?
Yes, Your Honor, I'd argue there's no probable cause. There's no allegations that this is domestic under the domestic violence statute, and so I'd be asking for release outright.
State. Yeah, I don't see whether it says living together or.
At this moment in time, Your Honor, the state would stipulate to that.
That there's no domestic relationship between the parties. All right, and so you. I guess probable cause, I guess non-DV. And is pretrial willing to take the defendant or release the defendant to pretrial alternate
Your
bond?
Honor.
Okay, yes.
Your Honor, if there's no probable cause, she is supposed to be released outright with no
Your Honor,
pretrial conditions.
if I may,
And it
she-
sounds like the state stipulates.
I apologize. To it being not being a DV case, however, it is still a battery. They were charged alone as battery, not as a domestic violence battery. Therefore, what would happen is it would be set in DV court and transferred to county court. However, if Your Honor finds probable cause, period, not being a domestic violence issue, she's still there's still probable cause for a battery alone, as is charged.
Right, I do find probable cause as to the battery. So she'll be released, pretrial alternate bond, 500. Okay. No, fine, this one.
Judge, you said, pretrial release alternate.
Yes. And so they're gonna give me a non-DV.
I
Oh,
am
okay.
right now, we're not gonna be stay away order.
Public defenders are appointed.
There'll be a non-DV stay away order from the victim in this case. All right, so we're ready for the next case is that Mayra Gonzalez.
Yes, Your Honor, and we do require the assistance of the Spanish interpreter.
Present. Thank you.
All right, good morning, ma'am.
Buenos días, señora.
Buenos días.
Good morning.
Give me a moment of reading the arrest form.
Segundito, estoy leyendo el informe del arresto.
All right, state.
Yes, Your Honor. In this case, the state would ask for standard bond.
La fiscalía está pidiendo la fianza estándar.
What's the standard bond?
Be $1,000, Your Honor.
Okay.
I'm sorry for the interpreter. How much?
$1,000.
Got it. Thank you. $1,000.
Defense, any argument as to probable cause?
Your Honor, none at this time.
All
El
right.
juez pregunta a la defensa si hay algún tipo de argumento para motivo fundado. La defensa dice que no.
All right, so the court will find probable cause as to this battery. Is pretrial willing to take? All right, so she'll be released to pretrial services. Alternate bond $1,000.
Desde este despacho, haya que hay motivo fundado para el cargo de agresión física, se le da permiso que vaya al servicio de excarcelación o servicio previo al juicio como alternativa fianza de $1,000.
So, Ms. Gonzalez, you're going to be released to pretrial services, but there are some additional conditions that you must also comply with.
Señora González, se le va a poner en libertad al servicio previo al juicio, pero hay algunas condiciones con las cuales usted también tiene que cumplir.
All right, if you are released, you shall not engage in any criminal activity.
Si a usted la ponen en libertad, no deberá ejercer o participar de ningún tipo de actividad delictiva.
You shall not use or possess any illegal drugs.
Tampoco podrá estar en tenencia de ningún tipo de drogas ilícitas.
You shall not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Tampoco podrá estar en tenencia, comprar o portar ningún tipo de armas, armas de fuego ni municiones.
If you own a gun, firearm, ammunition, you must immediately surrender any firearm, ammunition, and any concealed weapons permit to the nearest police department and file a receipt with the court.
Si usted tiene algún tipo de armas, armas de fuego, municiones o permiso para portar armas, tendrá que entregarlos de inmediato a la estación de policía más cercana. Allá le darán un recibo, el cual usted tendrá que entregar o radicar ante un tribunal.
You are prohibited from having any direct or indirect contact with the following person, the victim in this case, including contact in person, in writing, by telephone, through social media, or through a third party.
Usted no podrá tener ningún tipo de contacto ni directo ni indirecto con la siguiente persona que voy a decir, que es la presunta víctima o la víctima. En este caso, no podrá escribirle ni mandarle razones con nadie, ni por ningún otro medio electrónico, ni de ninguna manera lo podrá contactar.
And you must stay at least 500 feet away from the victim's home, place of employment, and or school at all times.
Y en todo momento tendrá que mantenerse por lo menos a 500 pies de distancia de donde la víctima vive, trabaja o estudia.
Court finds that the protected party is a spouse and cohabitated with the defendant.
Este despacho halla que la víctima es el esposo quien vivía, compartía en el techo con con la acusada.
The defendant may return to the victim's residence one time within 48 hours of the entry of this order, accompanied by a police officer to retrieve his or her personal clothing, personal health items, medication, personal and business-related paperwork, and work tools.
La acusada podrá regresar dentro del lapso de 48 horas después de haber sido puesta en libertad solamente una vez, y eso acompañada de un policía, y solamente para recoger sus artículos personales, sus medicinas, medicamentos, documentos de trabajo, documentos personales y ropa.
Going to the home or remaining at the home without the police will subject the defendant to arrest. The police officer shall request all keys and garage door openers to the home from the defendant and turn those over to the victim.
Ir a la casa sin la policía o quedarse allá la hará sujeta a ser arrestada. Tendrá que también entregar cualquier llave o cualquier tipo de llave del garaje a la policía.
State any objection to non-physical contact since they are married.
I apologize, can Your Honor repeat?
Do you have any objection to allowing non-physical contact since the parties are married?
El juez le
Yes,
pregunta a la
we'd be
fiscalía
objecting
si
to
tiene algún inconveniente en que haya algún tipo de contacto no físico, dado que están casados.
So you do not want the contact?
No comment.
Okay.
Si la fiscalía no quiere que haya ningún contacto.
All right, is there anything else? I think that's all the additional conditions, ma'am, and you are released. Please listen to the advice of your attorney.
Esas serían todas las condiciones. Por favor, preste atención al consejo que le da su abogada.
All right, the next one is this Janitza Vasquez.
Good morning, Your Honor. She's present before the court.
Okay, thank you. Give me a moment to read the A form. All right, any argument as to probable cause?
Yes, Your Honor. I would argue that there's no probable cause here for DV. It doesn't appear that there's any information about these individuals having a child in common or living together.
It says that we're conducting a custody exchange with the victim.
Yes, Your Honor. And I would just argue that the four corners of the A form do not explicitly state that there is a child in common. A custody exchange doesn't necessarily mean that there was a child in common.
Although it may not explicitly state that there's a child in common, one can gather from a custody exchange and the presence of police there indicated most would assume that a custody exchange is exchanging children that you have custody over. So I would argue that in this particular case, being as there is presumably a child in common, it would be a domestic violence case.
All right, court will find probable cause as to the battery and that it's domestic. All right. Okay, and pretrial is not willing to take the defendant. State argument as to bond and. All right, court will set bond at $1,000. I don't have the. All right, so Ms. Vasquez, the court has found probable cause as to the battery. Set your bond at $1,000. Pretrial was not willing to take you, but if you are able to bond out, there's some additional conditions to your bond that I'm going to explain to you now that you must comply with. So if you are able to be released, you shall not engage in any criminal activity. You cannot use or possess any illegal drugs. You cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. If you must immediately surrender any firearm, ammunition, and any concealed weapons permit to the nearest police department and file a receipt with the court. You are prohibited from having any contact, direct or indirect, with the following person, the victim in this case, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third parties. You must stay at least 500 feet away from the victim's home, place of employment, and or school. I'm gonna I'm assuming the protected party, although may not be a spouse, but and didn't say whether they cohabitated together, but probably does have a child in common. If you were cohabitating with the victim in this case, I'll allow you to return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer to retrieve your personal clothing, personal health items, medication, personal and business-related paperwork, and work tools. Going to the home or remaining at the home without the police will subject you to arrest. The police officer shall request all keys and garage door openers to the home from the defendant and return them to the victim. I guess no non-physical contact. And the other ones also does not apply. Is there anything else? Anything from the state? All right, anything from the defense? Okay.
Nothing further, Your Honor.
All right, thank you both. All right. Next case is Jessen Francois.
Your Honor.
Email.
Oh, that's a man. Oh, let's. Do you have Yes, sir, Garcia?
Can I ask what correction statement?
Your Honor, we have Chifravella. She's an add-on.
Oh, I mean, I was going by the order. This one does say black male. But we're only doing females at this time?
Yes, Your Honor. I believe there's a write-in, Miss Chiravella.
Let's see. Do we have paperwork here? Oh, here it is. Let's see. All right, is it Lelis Chervila?
Yes, Your Honor.
Okay.
And she does require the assistance of a Spanish interpreter.
All right, Mr. Barron? You
Yes,
still
Your
there?
Honor. Yes,
Okay.
yes, Judge.
Okay. All right, give me just a moment. Good morning. Give me a moment to read the A form.
Buenos días, un segundito mientras miro el informe del arresto.
No, we haven't done that.
All right, any argument as to probable cause?
None at this time, Your Honor.
Okay, so court does find probable cause.
El juez pregunta si hay argumento para motivo fundado, la abogada dice que no, entonces el juez halla que hay motivo fundado.
As to the battery and that it is domestic related.
Y hallo que este caso de agresión física tiene que ver con violencia intrafamiliar.
What happened to?
We're not sure if she has prior, so I'm not sure if we can determine eligibility for pretrial services.
The interpreter couldn't hear.
I apologize. We do not have her prior, so I don't believe at this moment in time we can determine if she's eligible for pretrial services.
Got it, thank you. La fiscal dice que no encuentran ahorita, no tiene acceso a los antecedentes penales, así que por tanto ellos no pueden determinar si ella califica para el servicio previo al juicio.
So at this moment in time, state would ask for standard bond.
Entonces, por ahora la fianza pide la fiscalía pide la fianza estándar.
All right, court will set bond at $1,000.
Este despacho fijará la fianza a $1,000.
If they haven't provided, an order.
We had to get domestic violence stay away orders. ASA David went downstairs.
We have just a form so I can at least read it, because I don't have, give me from the other cases. Okay, all right. All right, Ms. Charavella, if you are able to post your bond, there's some additional standards of your release that you're gonna have to comply with.
En la Charavela, si usted paga la fianza y puede salir, hay unas condiciones de excarcelamiento con las cuales tiene que cumplir.
If you are released, you shall not engage in any criminal activity.
Si usted es puesta en libertad, no podrá ejercer ningún tipo de actividad delictiva.
You shall not use or possess any illegal drugs.
No podrá tener ningún tipo o estar en tenencia de drogas ilícitas.
You shall not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Tampoco podrá portar, tener, comprar, estar en tenencia de ningún tipo de armas, armas de fuego o municiones.
You must immediately surrender any firearm, ammunition, and any concealed weapon permit to the nearest police department and file a receipt with the court.
Y si tiene algún tipo de armas o armas de fuego o permiso para portar armas, tendrá que entregarlo de inmediato a la estación de policía más cercana y el recibo que le den allá tendrá que radicarlo ante la corte.
You are prohibited from having any direct or indirect contact with the following persons herein, the victim in this case, including contact in person and writing, by telephone, through social media, or through third parties.
No podrá tener ningún tipo de contacto directa ni indirectamente con la víctima en este caso, no podrá contactarlo en persona ni a través de tercero, tampoco por las redes sociales ni por ningún medio electrónico.
You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times.
Y en todo momento tendrá que mantenerse alejada por lo menos a 500 pies de distancia de donde esa víctima vive, trabaja o estudia.
And the court does find that the protected party is an individual who cohabitated with the defendant.
Este despacho halla que la víctima es un individuo que vivía en común o compartía o vivía bajo el mismo techo con la acusada.
Ma'am, you'll be allowed to return to the victim residence one time only within 48 hours of entry of this order, accompanied by the police, to retrieve her personal clothing, personal health items, medication, personal and business-related paperwork, and work tools.
Señora, después de que esta orden haya sido puesta, haya sido hecha efectiva, usted tendrá 48 horas para regresar acompañada solamente de un policía a la casa para sacar sus medicinas, medicamentos, documentos importantes, pertenencias, ropa y herramientas de trabajo.
Going to the home or remaining at the home without the police will subject the defendant to arrest. The police
Ir a la
officer.
Go ahead, I'm sorry, my bad. Go ahead, Judge, I'm sorry.
I'll just going to the home or remaining at the home without the police will subject the defendant to arrest.
Ir a la casa sin la policía o quedarse en la casa la hará sujeta a que la arresten.
The police officer shall request all keys and garage door openers to the home from the defendant and turn them over to the victim.
La policía será quien le va a pedir las llaves de la casa y las llaves del garaje y se las entregarán ellos mismos a la víctima.
All right, any additional conditions? All right, good luck, ma'am.
Buena suerte, señor.
All right, so that was all of the females, or? Okay. So we're gonna go, so this is Jessa and Francois? Okay,
Yes, Your Honor.
All right, good morning, sir. Give me a moment to read the A form. Mm-hmm. 13 years. Mhm. When any argument as to probable cause?
None at this time, Your Honor.
All right, court does find probable cause for domestic battery. Okay. Pretrial is willing to accept Mr. Francois. She'll be released to pretrial services, alternate bond, $1,000. What? Yeah. So, Mr. Francois, if you're, once you are released, there are some additional conditions of your bond that I have to go over with you. If you are released, you shall not engage in any criminal activity. You shall not use or purchase any illegal drugs. You shall not purchase, possess, or carry a firearm, gun, weapon, or ammunition. And you must immediately surrender any firearm, ammunition, and any concealed weapons permit to the nearest police department and file a receipt with the court. You're prohibited from having contact directly or indirectly with the victim in this case, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. You must stay at least 500 feet away from the victim's home, place of employment, and school. I believe I read that the parties were cohabitating together and did have a child in common. So that means you may return to the victim's home one time only within 48 hours of the entry of this order, accompanied by a police officer to retrieve his personal clothing, personal health items, medication, personal and business-related paperwork, and work tools. Going to the home or remaining at the home without the police will subject the defendant to arrest. The police officer shall request all keys and garage door openers to the house from the defendant and return them to the victim. All right, any questions? All right, all right. Guess the next one is it Yasser Garcia?
He has a hold for immigration.
All right, so he's not being brought out today?
Yes, Your Honor. He's here.
Okay. All right, give me a moment to read the arrest report. All right, and any argument as to probable cause?
None at this time, Your Honor. Mr. Garcia does require the services of the interpreter.
Okay. All right, so Mr. Garcia, court does find probable cause as to domestic battery.
Señor García, para ese caso, el juez halla que hay motivo fundado para el cargo de por violencia intrafamiliar.
And not eligible, you're not eligible for a pretrial release. Court will set a bond in the amount of $1,000.
No
Your Honor,
califica para,
defense,
no califica para el servicio previo al juicio. El juez deja una fianza de $1,000.
Your Honor, defense would be requesting a lower bond since he is being held with an ICE hold. We would just be asking that the bond is lower.
La defensa está pidiendo que le reduzcan la fianza dado que ya tiene una orden de retención migratoria.
Any response from the state?
The interpreter can't hear the state.
I apologize. The state would be asking for standard bond be implemented in this case.
All right, court will leave the bond at $1,000.
La fiscalía está pidiendo que dejen la fianza estándar, así que el juez la va a dejar a $1,000.
Now, Mr. Garcia, if you're able to post the bond and get released, even and resolve your immigration, if you're released prior to the disposition of this case, there's some additional conditions of bond that I have to go over with you.
Señor, entonces si usted le llegan a dar libertad antes de que usted pueda pagar alguna fianza, hay ciertas condiciones de encarcelamiento que tengo que repasar con usted.
All right, if you are released, you shall not engage in any criminal activity.
Si usted lo pone en libertad, no podrá participar de ninguna actividad delictiva.
You shall not use or possess any illegal drugs.
Tampoco podrá estar en tenencia o portar drogas ilícitas.
Shall not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Tampoco podrá comprar, estar en tenencia o portar ningún tipo de armas, armas de fuego o municiones.
You must immediately surrender any firearm, ammunition, and any concealed weapons permit to the nearest police department and file a receipt with the court.
Y cualquier arma de fuego, municiones que usted tenga o permiso para portar armas o salvoconducto tendrá que entregarlos al departamento de policía más cercano y radicar un recibo que le den allá ante la corte.
You're prohibited from having any contact, direct or indirect, with the victim in this case.
A usted se le prohíbe que tenga cualquier tipo de contacto con la víctima, en este caso, bien sea directa o indirectamente.
And no contact means in person, in writing, by telephone, through social media, or any other electronic means, or through a third party.
Y no tener contacto significa que no la puede contactar ni directa ni indirectamente de ninguna manera, ni por las redes sociales, por teléfono, por texto, en persona. Tampoco le puede mandar razones con nadie, o sea, no la puede contactar en lo absoluto.
You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times.
Y no solamente eso, sino que tampoco se le podrá acercar a menos de 500 pies en ningún momento, ni donde la persona vive, trabaja o estudia.
The court finds that the parties did cohabitate together and have a child in common.
Este despacho halla que las partes vivían en común bajo el mismo techo y compartían un hijo, un niño en común.
All right, again, if you are able to be released, you may return to the victim's home one time only within 48 hours of entry of this order, accompanied by a police officer.
Si puede salir en libertad, una vez haya salido, tendrá 48 horas después de que esta orden haya sido efectiva, puede ir solamente a la casa una vez acompañado de un policía.
And you're allowed the residents to retrieve personal clothing, personal health items, medication, personal and business-related paperwork, and work tools.
Podría ir solamente una vez para que recoja sus cosas, sus pertenencias, su ropa, documentos de trabajo, herramientas de trabajo, medicina.
Going to the home or remaining at the house without the police will subject the defendant to arrest.
Ir a la casa sin estar acompañado de un policía o quedarse en la casa lo hará sujeto a que lo arresten otra vez.
The police officer shall request all keys and garage door openers to the home from the defendant and turn them over to the victim.
Es el policía quien le pedirá las llaves de la casa y del garaje y se las va a entregar a la víctima.
Any questions, Mr. Garcia?
¿Alguna pregunta, señor García? The interpreter can't hear.
None, Your Honor.
La
Okay.
defensa dice que no.
All right, thank you, sir. Good luck.
Señor, buena suerte.
All right, do we have Ronald Mojica?
Yes, Your Honor, he's present.
Okay. Give me one moment. Give me a moment to read the arrest report. All right, any argument as to probable cause for, I guess, violation of injunction?
Your Honor, I guess just defense would argue that within the four corners, there is no information about the validity of the stay away order.
Well, it says the subject is currently subject to a Miami-Dade stay away order, and they gave the case number.
Yes, Your Honor.
All right, so I'll find probable cause as to violation of a domestic violence stay away order.
Your Honor, in this case, the state would ask for an elevated bond, being as the defendant has substantial priors, many of his arrests being violent offenses and some of his convictions being for battery. The state would be asking for a bond of $2,500.
And no pretrial, correct? Okay, any argument as to bond for defense?
Your Honor, I would just be arguing that there's nothing within this case that would necessitate an elevated bond. The state talks about prior arrests, but many of these cases have been no actioned or null prossed. And it looks like what convictions there have been nonviolent offenses. And so defense's position that it would be that standard bond is appropriate.
All right, let me find these priors. And the defendant does have an extensive record going back some time. All right. Court will set bond at $2,500. And Mr. Mojica, if you're able to make bond, there's some additional conditions of bond that I have to go over with you. If you're able to make the bond, you shall not engage in any criminal activity. You shall not use or possess any illegal drugs. You shall not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. And you must immediately surrender any firearm, ammunition, and any concealed weapons permit to the nearest police department and file a receipt with the court. You are prohibited from having any direct or indirect contact with the victim in this case, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through a third person. You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times.
The yellow one. So because the white one goes to them. Oh, okay, so.
But if you were cohabitating together, you may return to the victim's home one time within 48 hours of the entry of this order, accompanied by a police officer, to receive personal clothing, personal health items, medication, personal and business-related paperwork, and/or work tools. But going to the home or remaining at the home without the police will subject the defendant to arrest. The police officer will request or shall request all keys and garage door openers to the home, and the defendant shall turn them over to the victim, from the defendant, and turn them over to the victim. All right, good luck. Yes. 2,500. This next is Vladimir Garcia.
Yes,
Yeah.
Your Honor, and he does require the services of the interpreter.
Got it, thank you.
All right, good morning, sir. Give me a moment to read the arrest form.
Buen día, señor. Un momentico, déjeme leo el informe del arresto, le dice el juez.
Any argument as to probable cause?
None at this time, Your Honor.
La defensa no tiene argumento para motivo fundado en este momento.
All right, so the court will find probable cause as to domestic battery.
Este despacho halla que hay motivo fundado para agresión física a nivel familiar.
All right, he's not eligible for a pretrial.
Él no califica para el servicio previo al juicio.
State any argument as to bond.
Standard bond is fine with the state, Your Honor.
I'm sorry, what was that again?
Standard bond.
Got it, thank you. La fiscalía dice que la fianza estándar está bien, thanks.
All right, court will set bond at $1,000. Mr. Garcia.
Go ahead. I can do it 2 or 3 phrases at a time, Your Honor. I'm sorry.
So, Mr. Garcia, if you are able to make bond, there's some additional conditions of release that I have to go over with you.
Señor García, entonces la fianza queda $1,000. Si usted puede pagar la fianza, hay unas condiciones para escarcelamiento de las cuales le tengo que hablar.
All right, so if you are able to be released, you shall not engage in any criminal activity.
Si usted lo llegan a poner en libertad, usted no podrá participar de ninguna actividad delictiva.
You shall not use or possess any illegal drugs.
No podrá estar en tenencia ni tampoco usar ningún tipo de drogas ilegales.
You shall not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No podrá tampoco estar en tenencia en un tipo de arma de fuego ni municiones.
And you must immediately surrender any firearm, ammunition, and any concealed weapons to the nearest police department and file a receipt with the court.
Cualquier arma que usted tenga, municiones o permiso o salvoconducto para portar armas, tendrá que entregarlo de inmediato a la estación de policía más cercana y entregar un recibo que le den allá ante la corte.
You're prohibited from having any direct or indirect contact with the victim in this case.
Se le prohíbe tener cualquier tipo de contacto, bien sea directo o indirecto, con la víctima en este caso.
Including contact in person, in writing, by telephone, through social media, or any other electronic means, or through a third person.
Eso incluirá cualquier tipo de contacto, bien sea directo o indirectamente, a través de terceros. No le puede mandar razones con nadie, tampoco puede llamar por teléfono, ni por ningún medio electrónico, ni por las redes sociales.
You must stay at least 500 feet from the victim's home, place of employment, and/or school at all times.
Y en todo momento tendrá que mantenerse alejado de donde la víctima vive, trabaja o estudia.
Court finds that the victim in this case is the spouse of the defendant and they do have children in common.
Este despacho halla que la víctima en este caso es la esposa del acusado y que tienen niños o hijos en común
And they cohabitated together.
y que viven juntos.
And so therefore, sir, if you're able to be released, you may return to the victim's home one time only within 48 hours of the entry of this order, accompanied by a police officer.
Por tanto, señor, si usted puede salir en libertad, tendría 48 horas después de que esta orden sea puesta en efectivo, acompañado solamente de un oficial de policía, solo no puede volver.
You're allowed to return to the residence at one time to retrieve personal clothing, personal health items, medication, personal and business-related paperwork, and work tools.
Podrá ir solamente una vez acompañado de un policía para que saque su ropa, medicina, documentos de trabajo, documentos personales y cualquier otro tipo de sus pertenencias.
But going to the home or remaining at the home without the police will subject you to arrest.
Pero ir a la casa sin la policía o quedarse en la casa lo hará sujeto a ser arrestado.
The police officer shall request all keys and garage door openers to the house, to the home from the defendant and turn them over to the victim.
La policía le va a pedir al acusado las copias de todas las llaves y las llaves del garaje y se las va a entregar a la víctima.
All right, good luck, sir.
Buena suerte, señor.
Thank you.
Do we have Leopoldo Fernandez?
And Your Honor, he requires the assistance of a Spanish interpreter.
Got it, thank you.
All right, good morning, sir. Give me a moment to read the arrest report.
Buenos días, señor. Déjeme leer el informe del arresto un momento.
Any argument as to probable cause?
None at this time, Your Honor.
All right, court finds probable cause for domestic battery.
Este despacho halla que hay motivo fundado para el cargo de violencia intrafamiliar o agresión física por violencia intrafamiliar.
Is he eligible for pretrial release? All right, is that eligible?
Está mirando a ver si califica para el servicio previo al juicio.
All right, any argument as to bond?
No, Your Honor, the state is no, Your Honor, the state is okay with standard in this case.
No hay argumento en cuanto a fianza. La fiscalía está pidiendo la fianza estándar.
All right, the court will set bond at $1,000.
El juez va a dejar la fianza a $1,000.
And Mr. Fernandez, if you are able to be released, there's some additional conditions of your release that I have to go over with you.
Señor Fernández, si usted lo pone en libertad, hay unas condiciones que me toca repasar con usted.
All right, if you're able to be released, you shall not engage in any criminal activity.
Si usted lo sueltan, usted no podrá participar de ningún tipo de actividad delictiva.
You shall not use or possess any illegal drugs.
Usted no podrá estar en tenencia o usar ningún tipo de drogas ilícitas.
You cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No podrá comprar, estar en tenencia o portar ningún tipo de armas, armas de fuego o municiones.
And you must immediately surrender any firearm, ammunition, and any concealed weapons permit to the nearest police department and file a receipt with the court.
Y cualquier arma de fuego o municiones que tenga, tendrá que entregarlas a la estación de policía más cercana y le van a dar allá un recibo que usted tendrá que radicar ante la corte.
You are prohibited from having any direct or indirect contact with the victim in this case.
Usted se le prohíbe que tenga cualquier tipo de contacto, bien sea directo o indirecto, con la víctima de este caso.
And that includes contact in person, in writing, by telephone, through social media, or any other electronic means, or through a third person.
Y eso implicaría incluso contacto, bien sea en persona o por escrito o por teléfono, por cualquier medio electrónico, por las redes sociales o aún por terceros.
You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times.
Y en todo momento tendrá que permanecer por lo menos a 500 pies de distancia de donde esa persona vive, trabaja o estudia.
From the arrest form, I understand that the parties did cohabitate together and did have children in common, although they were not married.
Según entiendo de lo que dice el informe del arresto, las partes vivían juntas y aun cuando, Your Honor, for the interpreter, they cohabitated by they did or did not have children in common.
They had children in common and they cohabitated together, but they were not married.
I got it, thank you, Judge. Entonces tenían hijos en común y vivían juntos aun cuando no estaban casados.
So the defendant may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer.
Así que podrá regresar dentro de un lapso de 48 horas después de que se haya firmado esta orden.
You'll be allowed to return to the resident only to retrieve personal clothing, personal health items, medication, personal and business-related paperwork, and work tools.
Podrá regresar solamente una vez acompañado de un policía, no puede volver solo, solamente para que saque sus artículos personales, herramientas de trabajo, papeles de trabajo, medicamentos.
Going to the home or remaining at the home without the police will subject the defendant to arrest.
Ir a la casa sin la policía o permanecer, quedarse en la casa, lo hará sujeto a que sea arrestado de nuevo.
The police officer shall request all keys and garage door openers to the home from the defendant and turn them over to the victim.
El policía le va a pedir las llaves de la casa y del garaje y se las va a entregar a la víctima.
All right, good luck, sir.
Buena suerte.
Do we have Miguel Barrios Hurtado?
Yes, Your Honor, and he does require the assistance of a Spanish interpreter.
Got it.
All right, good morning, sir. Give me an opportunity to read the arrest form.
Buenos días. Un momento, señor, mientras leo el informe del arresto.
All right, any argument as to probable cause?
None at this time, Your honor.
All right, court finds probable cause for domestic battery.
No hay argumento para motivo fundado. El juez halla que sí hay motivo fundado para violencia intrafamiliar.
All right, you are eligible for pretrial services. Court will order pretrial services with an alternate bond of $1,000.
Usted califica para el servicio previo al juicio. Como alternativa se le aprueba una fianza de $1,000.
So, Mr. Barrios Hurtado, if you're, upon your release, there's some additional conditions of bond that I have to go over with you.
Señor Hurtado, una vez usted se ha puesto en libertad, hay unas condiciones que tiene que cumplir y tengo que hablarle de eso.
Upon your release, you shall not engage in any criminal activities.
Una vez se ha puesto en libertad, no podrá ejercer ningún tipo de actividad delictiva.
You shall not use or possess any illegal drugs.
Tampoco podrá consumir o estar en tenencia de ningún tipo de drogas ilícitas.
You shall not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Tampoco podrá usar, portar o estar en tenencia de ningún tipo de armas, armas de fuego o municiones.
And you must immediately surrender any firearm, ammunition, and any concealed weapons permit to the nearest police department and file a receipt with the court.
Y cualquier tipo de arma que usted tenga o municiones o permiso para portar armas tendrá que entregarlo en el departamento de policía más cercano y radicar un recibo que le van a dar allá ante la corte.
You're prohibited from having any direct or indirect contact with the victim in this case.
Se le prohíbe que tenga cualquier tipo de contacto directo o indirecto con la víctima en este caso.
And that includes contact in person, in writing, by telephone, through social media, or any other electronic means, or through a third person.
Eso incluye contacto por escrito, por las redes sociales, por teléfono o por cualquier medio electrónico o aún a través de terceros. No lo podrá hacer.
Now, you must stay at least 500 feet away from the victim's home, place of employment, and or school at all times.
En todo momento tendrá que permanecer por lo menos a 500 pies de distancia de donde la víctima vive, trabaja o estudia.
Find that the parties did cohabitate together.
Digo que las partes vivían juntas.
Therefore, if upon your release, you may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer.
Así que se le autoriza que vaya una vez después de 48 horas de que haya sido esta orden hecha efectiva. Puede ir solamente acompañado de un oficial de policía.
And you're allowed to return just this one time to retrieve personal clothing, personal health items, medication, personal and business-related paperwork, and work tools.
Podrá ir solamente una vez para que recoja sus pertenencias, ropa, medicinas, papeles de trabajo, herramientas de trabajo.
Going to the home or remaining at the home without the police will subject the defendant to arrest.
Ir a la casa sin la policía o quedarse en la casa lo hará sujeto a que lo arresten.
You must, the police shall request all keys and garage door openers to the home from the defendant and return them to the victim.
La policía le va a pedir a usted las llaves del garaje o de la casa para que se las entregue ellos mismos a la víctima.
All right, good luck to you, sir.
Buena suerte, señor.
Your Honor, that was pretrial alternate 1,000.
Yes.
Thank you.
Do we have Alvaro Batista?
Yes, Your Honor, he's present and he requires the services of the interpreter.
All right. Good morning, sir. Give me a moment to read the arrest form.
Buenos días, señor. Un momentico, vamos a leer informe del arresto.
Any arguments as to probable cause?
None at this time, Your Honor.
La defensa no tiene argumento para motivo fundado.
Court does find probable cause for domestic battery.
El juez halla que hay motivo fundado para el cargo de agresión física en un caso de violencia intrafamiliar.
Is he eligible for pretrial? All right, you shall be released to pretrial services with an alternate bond of $1,000.
Lo van a poner en libertad al servicio previo al juicio. Como alternativa puede pagar una fianza de $1,000.
Your Honor, he has 3 counts.
Tiene 3 cargos.
I see. Count 1 for battery, 2 for battery. What's the third count? Were these 3 within one episode?
Yes, Your Honor, it was all in the same incident. So as long as Your Honor can do standard bond $1,000 on each count as an alternative, the state would be fine with that.
Es
Or
que el
otherwise,
problema es que se le autorice, son 3 cargos durante el mismo episodio, el mismo incidente, pero son 3 cargos diferentes. Se le puede autorizar $1,000 de fianza para cada uno. La fiscalía no tiene problema con eso.
or the state would otherwise ask for just standard bond on each count.
Defense,
Your Honor, my only argument would be that the four corners of the charging document only include 2 counts.
I only see 2 counts here, and it appears that it's just one episode. I don't think you get an account for every, unless there was a,
A different, 3 different victims. So 3 different counts.
okay, let me-
La defensa y el juez dicen, veo solamente son 2 cargos. Dice la fiscalía, lo que pasa es que habrán 3 víctimas diferentes.
Yes, Your Honor, and if Your Honor would see the 3rd page of the arrest affidavit, it would indicate the contact made with victims 2 and 3.
okay.
En la página 3 aparece el contacto que se hizo con la víctima 2 y 3.
All right, maybe I didn't read further enough.
It's a long one.
Momento.
All right, so we had victim 1. That's Miss Rodriguez. Victim 2, Mr. Ramirez. Location is separate.
La Rodríguez, la señora Ramírez.
Thanks. And the 3rd victim. The 2nd and 3rd victims are not domestic.
Es que la segunda y la tercera no son parte del núcleo familiar.
They appear to be just residents that were staying, but are not related to the defendant.
Parece que son personas que estaban quedando, pero no son familiares del acusado.
That could be a possibility, Your Honor. But otherwise, the state would mention that they are, aside from the original victim or victim 1, I'd rather say rather than original, they're all charged just regular counts of battery, not domestic battery.
Igual, de todas maneras, sería lo opuesto a violencia intrafamiliar.
All right, so the court again finds probable cause as to all 3 counts. Release him to pretrial services. As to count 1, alternate bond $1,000. As to count 2, alternate bond $500. As to count 3, alternate bond $500.
Entonces, este despacho haya qué motivo fundado para cada uno de los 3 cargos de violencia, agresión física por violencia intrafamiliar. Le ponen libertad al servicio previo al juicio. Para el primer cargo, como alternativa son $1,000. Para el cargo 2 y 3, como alternativa 500 para cada uno.
Now, Mr. Batista, if you're able to, once you get out there, some additional conditions of release that I have to go over with you.
Señor Batista, una vez usted se ha puesto en libertad, hay unas condiciones que tengo que repasar con usted.
And this really would apply to Miss Rodriguez, victim 1.
Ahora, esto solamente aplica a la señora Rodríguez, que es la víctima número 1.
So if you are released, you shall not engage in any criminal activity.
Entonces, si lo pone en libertad, no podrá ejercer ningún tipo de actividad delictiva.
You shall not use or possess any illegal drugs.
Tampoco podrá estar en tenencia ni portar ningún tipo de armas, perdón, de drogas ilícitas.
You shall not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Tampoco podrá portar, comprar o usar ningún tipo de armas, armas de fuego o municiones.
And you must immediately surrender any firearm, ammunition, and any concealed weapons to the nearest police department and file a receipt with the court.
Y cualquier arma, arma de fuego o municiones que usted tenga, tendrá que entregarlos de inmediato en la estación de policía más cercana y el recibo que le den tendrá que radicarlo ante la corte.
You're prohibited from having any direct or indirect contact with the victim in this case. This is Ms. Rodriguez, victim in count 1.
Se le prohíbe tener cualquier tipo de contacto directo o indirecto con la víctima número 1, en este caso, la señorita Rodríguez.
Including contact in person, in writing, or by telephone, through social media, or any other electronic means, or through a third party.
Incluyendo contacto en persona, por escrito, por teléfono, por cualquier medio electrónico, por las redes sociales o por alguien más, por un tercero. Tampoco lo podrá hacer.
You must stay at least 500 feet away from the victim's home, place of employment, or school at all times.
Y en todo momento tendrá que permanecer por lo menos a 500 pies de distancia de donde esa víctima vive, trabaja o estudia.
Believe from reading that the victim and the defendant had children in common, but were not residing together at the time.
Tengo entendido que la víctima y el acusado tienen hijos en común, pero no vivían juntos para ese entonces.
Yeah. But as to the other two victims, they don't have domestic relationships with the defendant. It's like they were staying in the victim's residence in another room and became victims of the battery, but they don't have any domestic relationships with the defendant.
Ahora, en cuanto a las otras víctimas, estaban quedando ahí en otra habitación, no viven, pero fueron víctimas del acto de violencia intrafamiliar del acusado.
And so as to the two additional victims, we'll file a non-domestic stay away order from those two. I understand one of them, they work together in a barbershop.
En cuanto a las otras víctimas, se presentará una orden de alejamiento no de carácter doméstico. Uno de ellos trabajaba en una barbería.
All right, good luck, Mr. Batista.
Buena suerte, señor Batista.
Do we have any of, I have this Catherine Rohan.
Your Honor, there, Mr. William Rohan is here.
I mean, okay.
That's the TV.
Well, it's Ramon's.
Usually set aside at the DB warrant and I was by them.
All right, so this Mr. Williams Rohan that didn't appear. Oh,
Your Honor, Mr. Rohan was getting ready to be released on yesterday and this DB warrant popped up.
all right, and so what are you asking? Just to,
Your Honor, the judge signed a document saying that the respondent shall be held in custody until brought forth before a judge. At that hearing, the judge shall set this matter on the calendar with release conditions indicated, set on civil compliance and ROR, the respondent.
okay. All right, so you being RR today, sir, but you're reset for hearing on August the 27th at 1:00 p.m. And we have where the hearing is going to be at. Is that the Lawson E. Thomas?
Yes.
All right. It's courtroom 2A at the Lawson E. Thomas Courthouse Center. All right, okay, I'll quash the warrant that's been issued. So you understand, sir, you have to go to court.
I was in custody, sir, for all three hearings. Yes, I do.
Okay. All right, do we have an updated address for the defendant?
Your Honor, he does not have an address. And so if I may, what was the courtroom again?
It's courtroom 2A in the Lawson E. Thomas Courthouse Center.
I
And
have
that's,
been using the address for the stayaway as a
Don't
mailing
don't
address.
say anything on the record, sir.
all right, so he still has to stay away from the victim in this case. The previous conditions of the DV is still, I'm sorry.
Needs to re-enroll to the program. Also this one, and then show please what they use for groups.
So when it says that he has to re-enroll.
Yes.
I mean, is that something he's gonna get in writing here, or?
Judge, it should be the third form.
That's not what it says. Okay,
You're just signing that and let him know that he should re-enroll before the 27th.
all right, so you need to re-enroll to the advocate program before you have that hearing on the 27th. Oh, it says via Zoom.
No, it's in person.
Okay.
That was doing COVID, Judge.
All right, do you have any questions, sir?
None, Your Honor.
To what I check. Do I sign anything else? Anything over here?
Section, right? And the court date, August 27th, for civil compliance at 1 p.m. That would be it, Judge. Sorry.
Okay. All right, thank you, sir. Good luck to you. Let me take a moment. Break for one moment. Okay,
Have a great day.
all right.
Hi, this is video. I stepped away for a moment. Are we done with the domestic violence calendar?
Yes, we're done with the rest. We're getting set up, I guess, for felonies, misdemeanors, and then felony.
Okay, I'll stop the record for DV then.
Recording stopped.
All right, do we have someone for corrections that's on the Zoom at
Recording
this
in
time?
progress.
We're here, Your Honor.
All right, I have a counsel here in court. He's, I guess, you let him know what you're trying to do, counsel.
Good morning. My name is Brian Barracat. I represent Louis Urquejo. He's over at TGK. He was picked up last night, but somehow did not make the calendar for today. I'm trying to stipulate with the state to a standard bond. And I just want to make sure that I'm following your procedure to do so.
Your Honor, he did not make the calendar for today. He'll be on tomorrow's calendar.
But I'm trying to avoid the appearance by waiving his appearance. I represent him. Can I overcome the delay till tomorrow by stipulating with the government to a standard bond?
My apologies, counsel, but things have to be done in proper order. They need to contact, you should have contacted the clerk's office or the judicial assistant to let them know you want to try to put him on calendar. We don't have any information on the defendant or the jail card on the defendant, so he will be on tomorrow's calendar.
And so I guess not knowing what the charges are or anything about him, they're not gonna be willing to stipulate.
Well,
I
no,
guess,
the
to-
government is willing to stipulate. They do know the charges. It's a simple battery and a disorderly intoxicant progables. I have his jail number here. I have his case number here. We have his priors here. We have everything except for whatever other stuff I have to take.
But I mean, I got corrections in the clerk saying they're not willing to.
Is there anything I can do today to avoid him spending an unnecessary second night in jail on this misdemeanor?
But is he able to just bond out?
He does, there's no, so recently they changed it so that they don't give a regular bond on a battery case. So he's got a bond set on his disorderly intox, it's $150. And he's got no bond set on his simple battery claim. We are willing to stipulate to a standard bond. I just need it to go in so I can get the bond posted.
But with the, I guess the clerk saying they don't have any paperwork.
What can I do now? Because obviously there was no chance for me to call anybody's JA because he got picked up at midnight and I came here first thing in the morning. What can I do to get a jail card moved and to keep this guy from spending an extra day in jail on this misdemeanor? And that's questions for corrections. How can I overcome the problem?
Sir, it's not just us. You're dealing with the clerk's office as well. They have to have the files. No one has any information on the defendant. The clerk is, I don't even know where the clerk is, if they're in there with the judge at the moment.
Corrections, I'm here. Being that he did not print on the calendar, we do not have a file at all. As was stated before, he will be on the calendar tomorrow, and the clerk will have the file tomorrow.
So having been in court for the past 20 years, I know from the clerk's standpoint, we could pull the file on the computer. I know that can be accomplished. I've done it before, but it seems to be the only real impediment is corrections. Am I wrong in that?
Yes, you are. Being that we do not have the file, counsel, we cannot go upstairs and just pull a file when there has not been printed on this calendar. That comes from corrections to us. There's a format that takes place here.
I appreciate that. I am trying to overcome somebody sitting in jail for a night for no reason.
Right, but it appears, I guess, that either the time he was, I guess, arrested or booked in is why he didn't make the calendar this morning. I know there's a cutoff time.
Yeah, I think he got arrested at like 11 o'clock.
Yeah.
So he spent a full night in jail. He's gonna spend another full night in jail for. I'm happy to go wherever I need to go, talk to whomever I need to talk to. I just need to do what I can to keep a guy from rotting in jail for a night over, a small matter. Corrections, is there anything that I can do to overcome it?
No, Judge, I'm sorry, no, counsel, not at this time. Judge, are you ready for the next defendant?
Very good.
Well, I just wanted to make sure counsel's been here this morning and he's been very patient, but I want to make sure if there was something that we could do to that we did that. But if you're saying there's nothing that can be done, there's nothing.
I mean, can he be called down at the jail? Can his jail card be retrieved? Is it possible? I know he's in the building.
So correction, they're saying, can you pull him to bring him this morning, even though he's not on the list?
No, Your Honor, we've already spoken about that. We cannot do that. It's a process over here. The same way the clerk's office have a process, we have a process over here.
I appreciate your time.
All right, thank you. I'll see you tomorrow.
Good morning, Your Honor. This is Joanne Hennessy. I'm here for the city.
Ms. Hennessy, I cannot hear you.
Misdemeanor calendar.
All right, you have
Can you hear me now?
I can hear you, but you're going, sort of was going in and out.
Your Honor, may I approach with the misdemeanor priors?
Okay, but where are we doing Miami Beach? I see they're on, I'm not sure what we're doing right now.
Miami Beach should have a case. I believe I saw it, but it would be along the calendar.
Okay, so we're just gonna call it in as it goes through. Okay.
Your Honor, this is Joanne Hennessy. I'm here for the city of Miami Beach.
Okay.
Thank you.
All right, so it looks like the first one is Deborah Lynch. Is Miss Lynch there? Good morning.
Yes, Your Honor, she's present.
Okay. And
Your Honor, just to confirm, for all the misdemeanor cases, are you provisionally appointing the public defenders?
yes.
Thank you, Your Honor.
All right, so Miss Lynch did a bench warrant.
Does not have an actual file.
Oh.
It was not located.
Okay. And so what are we doing with Miss Lynch this
Just
morning?
asking for a standard bond and ASA Joshua David on behalf of the record for the state of Florida, and ask for a standard bond of $500 and the stay away order issued, which should be in front of you.
And is she homeless?
Yes, Your Honor.
No, I'm not.
You're not?
No.
Okay. My apologies, Your Honor.
All right. All right, so this case the trespass
This is a petty theft.
or petty theft?
I know it's incomplete, so we would have to correct that on our end,
Mm-hmm.
but
Okay, I see petty theft. And then she. So probable cause as to petty theft, bond of $500?
yes.
And Your Honor, defense would just argue that whatever the address that I believe that the clerk or the court had for Miss Lynch was not correct. So there's no way that she could have gotten notice. And therefore it is understandable that she would have bench warranted.
But I guess would assume the address that she had would have, I'm looking at let's see. On this A form, it's homeless assessment 28205 Southwest 124th Court. Is that?
And that is not her address, Your Honor.
They said the source was her, that she gave that to them verbally.
No, I don't even know Southwest section.
And so is she providing another address so that she can receive notice?
I do have the correct address now, Your Honor.
To state.
We won't object if she wasn't properly noticed.
So I mean, you're willing to release her?
Yeah.
RR?
Yes.
All right, probable cause release RR, but you have to provide your address to the clerk.
Okay.
So that notice will be given to her.
And yes, Your Honor, public defenders will ensure that a change of address form is filled out.
Okay.
Your Honor, that was the RR.
Yes.
Thank you.
All right. Anything else I gotta say? Oh, stay away from the Walmart on 19501 Northwest 27th Avenue, Miami Gardens. Okay.
And Your Honor, Miss Hippolyte, who is the next person, I believe does require the services of the Creole interpreter.
Okay.
Okay, I'll go ahead and call the crew interpreter. It'll be a few minutes, before she comes in.
All right, so can we pass this case?
Thank you.
Do we have Kayla Marie Descent?
Yes, Your Honor, she's present.
Okay. All right, good morning. She was charged with petty theft. All right. All right, State, what are we doing with this case?
We're just gonna ask for a standard bond of $500. Does have a previous withhold for controlled substance from 2022. We're just gonna ask for $500 standard.
Hold on, let me read. This is petty theft.
And then ask for a stay away order from the incident location.
All right, defense, any argument?
Not at this time, Your Honor.
All right. So Madam Clerk, where do I?
Everything's right.
In the comment section or up here?
No, right here. You doing a bond?
Yes.
Right there.
All right, so it's just probable cause bond 500.
And we would like to issue a stay
All
away.
right, stay away order.
Since we passed the defendants, it should be the second, right, or third.
Let's see. Yeah, stay away from the Kohl's store at 2455 Southwest 10th Court, Homestead. Okay. All right, good luck, ma'am. This is it Alid Ferrer?
Yeah. Yes, Your Honor.
What do we have here? Yeah. Okay, 1, 2, 3.
Your Honor, just FYI, whoever the host is, the current interpreters should be in the waiting room. Just wanted to let someone know.
Okay,
Mr. Interpreter, what's the name of the Creole interpreter?
Carol Wilson,
Understood. I'll look
thank you,
her right now.
thank you. In counsel, does this defendant need an interpreter? I'm not sure.
this is Miss Ferrer. Does she need interpreter, counsel?
No, she does not,
Okay.
Your Honor.
Got it. Thank you both.
All right, so she has, what, 3 cases of petty theft?
3 cases and 5 charges.
Okay,
And we're gonna ask for an elevated bond because she also has two other open petty thefts, another open grand theft, and another hired vehicle failed to deliver felony charge. So we're gonna ask for an elevated bond of $5,000.
defense?
Your Honor, I would just say that as to the bench warrants, again, the address here was not correct. I do have the correct address and I am going to make sure a change of address was submitted, but she could not have received notice for court.
Well, on the warrant case, it indicates that the address came from driver's license. All right.
Your Honor, the defendant could have updated their address when they were previously addressed the open cases, and so counsel at that time and the defendant at that time could have updated their address. Especially since these cases are all from this year.
All right, so the current case that she's for now is 25-17293. That's a petty theft. 3 counts. All right, court finds probable cause.
We're gonna also be asking for a stay away order from the incident location.
All right, so as to this one, count 1, bond 1,500. Count 2, bond 1,500. Count 3, bond 1,500. And a stay away order from
That's on M25172293.
yes. Stay away from the target. All right, as to the other 2, these were just bench warrants.
Yes, on the M25107770. And county, that's the 7.
All right, and what are we doing with those? Just so we're watching the warrant now because he's
Yeah, possible. On the $500 for one ending in 767 and 3,000 for the 77.
State, could you speak into the mic, please?
Excuse me. Oh yeah. So we're gonna ask for a standard bond on the case ending in 767 and a standard bond of 3,000 on 770.
And Your Honor, defense would just argue that she's being held on bond now on the other cases. And again, as I mentioned, there was not proper notice for the bench warrant, so we would be asked that she's ROR'd on those counts or on those cases.
well 25-01-0770. Quash the warrant. Set a bond of $1,000. And I guess on 25-1-0767. I guess I'm gonna also quash the warrant. And that's just 1 count.
Yes.
Bond 1,000. All right. Madam Clerk, make sure I've signed, and I guess, are there stay away orders here? For me to
Yes.
sign?
It should be on Your Honor. They should have seen if you stay away order, should be the other ones. Before the next time.
So this one is stay away from the Walmart, 5400 Southwest 24th Street. And the previous stay away orders will remain in effect. Good luck, ma'am. Do we have the Creole interpreter for Miss Hippolyte? yet?
Yes, Your Honor, you do. Good morning.
All right, good morning.
Good morning.
All right, so Miss Hippolyte. This is trespass after warning.
Madame Hippolyte, yo di kon sa ke rentre un kote apè yo te fin djou pa tourne la. Madame Hippolyte, yo djou kon sa kote rentre un kote yo te djou pa gen droit pour rentrer là.
And an interpreter, if you wouldn't mind advising her not to speak about
Madame,
the case or anything.
Madame avocat la di pou pa pale sou ka du tout. Pa di rien.
If I didn't look there, I tried to. Good. Yes.
Oh, you sign.
All right. Jake, this is a trespass, but
Because it was after warning, we're gonna ask for just a standard bond of $500. The defendant has no priors, but because she was warned, we're just gonna ask for a $500 standard bond.
Sa son ka ke l'entre un kote yo te di l pa rentre, li pralman de caution standard $500, li pa gen antécédent, mais yo te di ke l pa gen doit vini nan kote sa.
anything from the defense?
Yes, Your Honor, I would argue that there's no probable cause here. I would argue that there is a language barrier that could have prohibited the understanding of the stay away order. Additionally, it seems as though this is a long-term assisted living facility, which might mean that there may be some mental issues at play. And so I don't think that it's necessarily true that she did actually understood what was being said. So I would ask that she be released outright. She has no priors.
Juge la mande avocat la défense s'il pas gagné pour dire avocat la défense là dit comme ça que ou pas gen antécédent et que peut-être qu'on pas comprendre ça yote djou là et que côté aller c'est ton côté pour moun qui pas qu'à vivre pour compte yo qui obligé de ton côté gen l'autre moun et que peut-être que c'est pour ça côté retourner là.
Your Honor, to counter that, it says in the four corners of the A form that the defendant was advised multiple times over the course of an hour by a Creole speaking officer. So for more than an hour, someone in her own language was telling her that she was not allowed at this location and she still refused to listen.
Avocat l'État a dit comme ça que c'est ton officier de parler créole qui dure bien une heure de temps pile fois pour pas rien doit retourner là malgré tout pas coûter ça officier à t'abdia.
But I'm assuming that she would be otherwise homeless if she's not at these temporary housing center.
Yes, Your Honor.
Donc moi pense juge la dit ben pense que le pas gen côté pour le rete si c'est pour ça que là aller dans côté ça yo. Avocat la défense nan dit oui juge.
And so do I need to have this set for the homeless calendar?
Yes, Your Honor.
Est-ce que c'est pour me mettre pour calendrier moun qui sans abri yo, avocat la défense nan dit oui.
All right, I mean, I find probable cause, but I'm willing to release her or
Moi ouais que gen assez raison mais m'a plague sans caution.
I'm signing a stay away order from the Lotus Center, 217 Northwest 15th Street. You understand? She can't go back there.
Madame, m'a mettons l'autre campé loin de Lotus Center qui dans 217 Nord-Ouest 15e rue. Vous comprenez qu'on pas qu'à retourner là, pas vrai?
And Madam Clerk, this homeless date, do I put this on the form?
Yes, please.
All right, so we're resetting this case to the homeless calendar, which is on September 10th.
Donc, madame, n'a voyé ou dans l'autre date pour retourner dans le tribunal, là, dans le calendrier moun qui sans abri yo, qui c'est le 10 septembre.
And it's at 8:45 a.m.
À 8h45 du matin.
in courtroom 6-8.
Notre salle tribunal 6-8. 6-8.
Of the Richard E. Gerstein building.
Dans building Richard E. Gerstein, qui en bas Boko Jackson dans le 12e.
Does she understand that?
Vous comprenez, madame? Madame, vous comprenez? I understand.
Okay. All right.
Okay.
So you'll be released. You have to report to this, the homeless calendar on September the 10th, courtroom 6 to 8, and you have to stay away from the Lotus.
Ok, madame, y a plage ou gen pou al nan tribunal la le 10 septembre à 8h45, salle là c'est 6-8. Y a plage mais faut rester loin Lotus Center. Et dans le tribunal qui est dans 12e là, à côté Jackson là. Ok, madame.
Vamos tourner. Non, pas parler.
So dit?
Qui connaît me parler?
Where am I gonna live?
I don't know, ma'am.
M'pa konnen, madame.
I know. I am an hypocrite. I am an hypocrite.
I mean, they don't want you back at the
I am
Lotus
like
house,
police.
ma'am. I don't
Oui,
know
madame.
where.
Yo pa vlo tourner dans Lotus Center.
Where I'm going?
Interpreter, will you tell her that the phone number for the Office of the Public Defender is on the document that I just gave her so she can call?
Madame, numéro papier li sot ba ou a gen numéro téléphone avocat défenseur public là, ou an écrit le numéro ça.
Okay.
Okay.
All right, good luck.
Bonne chance.
Are we on, is this J. Maria Franklin?
Yes, Your Honor, she's present.
Okay. This is possession of cannabis and resisting without violence. Give me a chance to read this. Traffic stop.
I'm shitting you. This is my first time ever being in jail. I have no blood anymore. Okay. And I should be good. Okay. But just in case you need that phone number. And then
All right, any argument as to probable cause?
Your Honor, I would just argue that it's clear towards the beginning of the A form that there was no resisting. And I guess I would argue that becoming irate and shouting is not resisting.
I would argue that when the defendant removed her handcuffs, after being handcuffed, was it resisting her detention and or arrest. And just because she didn't resist in the beginning doesn't mean the episode ends or it ends with just because it wasn't resisting when she was first handcuffed doesn't mean she could not have resisted
All right.
her detention.
Court finds probable cause as to both counts.
$500 bond standard for each.
Any argument as to bond?
Your Honor, I would argue that this is her first arrest. There are no priors. I would ask that she be released on her own recognizance. The mailing address that we have for her is correct. She will show up at future court appearances.
All right, I'll issue RR on both counts. Do we have does she get a notice now or she gets it later for where she has to report?
She'll get it in the mail, Your Honor.
Okay. All right, so probable cause that's the 1 and 2, but I'll release her on her own recognizance. So good luck to you, ma'am.
Thank you, Your Honor.
All right, next is this Eva Santiago. And this is the Miami Beach case.
Yes, Your Honor, Joanne Hennessy for the city of Miami Beach.
Okay, give me a moment to read the A form. Does she need the interpreter?
Yes, Your Honor.
Okay,
Spanish
Spanish.
interpreter.
Present.
All right, any argument as to probable cause?
Yes, Your Honor. Pursuant to the statute that governs the prohibited camping, it requires that somebody is inside or covered. Sleeping on the beach is not enough. I would argue there's no probable cause here and that she should be released outright.
Pues pregunta si hay motivo fundado para el cargo de acampar. La defensora está presentando su argumento de por qué no hay o no debería haber motivo fundado para el acto de acampar.
Your Honor,
Yes.
if I may, Ms. Santiago was sleeping on the 1100 block of Collins Avenue, which is not the beach. In addition, the statute defines public camping or public sleeping is prohibited. Ms. Santiago was asleep on the public sidewalk on Collins Avenue at 11th Street, which is also prohibited by the statute.
Dice la persona demanda, el representante de la ciudad de Miami Beach, ella estaba durmiendo en la cuadra 1100 de Collins, de la avenida Collins, y aparte de eso, el estatuto prohíbe que se acampe o que se duerma, y ella estaba en esa cuadra durmiendo, la encontraron.
And Your Honor, I would just argue that a very plain reading of the statute, I just read it while I was reading the A form, requires that somebody be inside or covered and directly says that sleeping is not enough.
I mean, I don't have a copy of the ordinance. Can you read it to me? I don't have a copy.
Your Honor, if I could read the elements, and it was revised in
Well-
September of 2024. And it's public camping and public sleeping is prohibited. The definition for public camping and public sleeping means lodging or residing in an outdoor space as evidenced by the erection of a tent, temporary shelter, or possession or presence of bedding, pillows, personal belongings, lying, sitting, or resting on any item or material, or cooking on an open flame and fire outdoors, or sleeping outdoors, Your Honor. In this case, Ms. Santiago was sleeping outdoors on public property, which is prohibited by the statute, by the ordinance.
I'm sorry. La fiscal representante de Miami Beach está diciendo por qué el hecho de acaba de leer el estatuto, dice que el hecho de dormir en un área pública constituye el hecho de acampar y por lo tanto sí debería haber motivo fundado, contrario a lo que dice la defensa.
All right, I'll find probable cause as to public camping. As far as bond.
Hallo que hay motivo fundado en lo que tiene que ver con acampar en público. Ahora el juez quiere preguntar cuál sería la fianza.
Your Honor, I would ask for standard bond in this case, which is 150.
La fiscal está pidiendo la fianza estándar, que serían 150.
Any argument?
Yes, Your Honor. I would argue that Ms. Santiago does not have an extensive list of priors. In fact, it seems as though there was only one prior misdemeanor conviction. She is homeless. She cannot afford bond. I would ask that she is released on her own recognizance.
La defensa está pidiendo que le den libertad bajo palabra, dado que no tiene mayor cantidad de antecedentes penales, tiene solamente un fallo condenatorio en el pasado.
All right, I'll order the defendant.
Le voy a dar libertad bajo palabra, dice el juez.
Good luck to you, ma'am.
Buena suerte, señora.
Dios lo
Oh,
And-
and Your Honor, since she's
oh,
homeless, she does need a date certain on the homeless calendar.
Le van
Okay.
a dar una fecha precisa de cuándo regresar.
All right, so the homeless calendar is September the 10th at 8:45 a.m. in courtroom 6-8.
Entonces, la próxima audiencia la tendrá el 10 de septiembre a las 8:45 de la mañana en la sala 6-8.
Caballero, tengo una pregunta. Estoy libre.
Don't ask any questions right now. You can speak with your attorney, okay?
No, no, ahorita no haga ninguna pregunta, más adelante usted podrá hablar con su abogado o su abogada.
Pero, ¿qué dijo el juez? ¿Libre?
So,
All
am
right.
I being released?
Yes, ma'am.
Sí, señora.
Ok, gracias. Dios lo bendiga.
Thank you.
All right, so we are, is this Tawan Pond? Is that Pound or Pond? I can't read.
Yes, Your Honor, this is Mr. Pound.
Pound, okay. All right, this is petty theft, drug paraphernalia.
Yeah.
All right, any argument as to probable cause?
None at this time, Your Honor.
It's gonna ask for an elevated bond, since the defendant has been convicted of petty theft as recently as 2024, with 3 counts of petty theft in 2024. Another count in 2023 of petty theft he's convicted. He's been convicted of grand theft numerous times. So we're gonna ask for an elevated bond of $2,000.
Any argument as to the bond, counsel?
Yes, Your Honor, I would just argue that the state's arguments as to the grand theft convictions, those are old convictions. He has not had those felony cases recently. They look like they're from 2009, 2008, and 2014.
And so what's the standard bond?
The standard bond right now would be $300, Your Honor, but because he's convicted of petty theft in 2024 twice and once in 2023, recently, we would ask for, if you're not considering the grand thefts, at least a $1,500 of elevated bond.
Your Honor, the standard bonds are 150 on each count.
All right, haven't found probable cause, set bond as count 1, $250, as the count 2, $250. Is there a stay away from the?
Yes.
Stay away order, was it a Walgreens? Is it one here? Where is it? All right. All right, Mr. Pound, if you're able to bond out, you have to stay away from the Walgreens there on 199th and Northwest Second Avenue.
What if I'm not able to bond down, sir?
Then you'll remain until your next court date. Good luck to you. All right. I got a red folder that's empty. All right, Wayne, Alkin.
Aiken, sir.
Aiken,
Yes, Your
excuse
Honor.
me. Good morning.
Your Honor.
The trespass and
I'm
disorderly.
representing myself because that's my constitutional right.
Well, right now I've appointed the public defender to represent you.
Yes, I'm well aware of that.
Okay.
And it was taken in by all things trespassing. And I served 75 days here.
Sure. I would advise you don't say anything, okay?
All right, let's see. I just watched the Miracle Mile. Disturbance. Treated the first time.
As of today.
Argument as to probable cause.
Yes, Your Honor, I would argue that there's no probable cause as to count 2. Disorderly conduct requires that the defendant draw a crowd. The mere fact that there was a group of people or that there was a crowd is not sufficient. There's no probable cause as to disorderly conduct.
State.
I was simply there to let them know.
Hold on, sir.
Excuse me, sir, don't say anything, okay?
Right.
They has no argument to count 2. We don't see anything in the 4 corners of the A form that include a crowd forming.
All right, so court finds probable cause as to count 1, no PC as to count 2. Bond.
We're gonna ask for elevated bond because he was convicted of trespass in April of this year. Of an elevated bond of $1,000.
Defense.
Your Honor, I would argue that there is no reason for an elevated bond in this case. Mr. Aiken doesn't have an extensive list of priors, and I would argue that there's no reason for the bond to be elevated here.
Correct. I simply want to see his own.
All right, I'll set the bond as for count 1 at 750. No, RR as to count 2.
Your Honor, I would just ask that count 2 is released outright since there's no PC.
Okay.
Is that right now?
Yes, as to count 2, yes. And 750 as to count 1. All right, good luck to you, sir. And stay away, it's a stay away from the Denny's there. You gotta stay away from.
Back. Thank you, Your Honor.
Hold on. Let me find my son. Where? I don't see it. Oh, that right in front of me.
Yeah, they're in order.
Yeah. Yeah, you gotta stay away from Denny's.
Good morning.
Okay. And our next one is it Kevin Neal?
Yes, Your Honor, he's present.
All right, good morning, sir. Charged with trespassing. Inside the business.
And Your Honor, defense has no PC arguments at this time.
All right, court will find probable cause as to count 1. And bond?
We're gonna ask for an elevated bond. Yes, his priors are extensive. Going all the way back. As recently, he was convicted of controlled substance in May of this year. And he was convicted of petty theft in
defense as to, you said elevated, but what?
Yeah, we're gonna just elevate this to 750 from $500.
Defense?
Your Honor, I would just argue that Mr. Neal is homeless. He does not make any money. He will not be able to afford that bond, and non-monetary release is the presumption.
I just started working next door.
All right, I'll RR the defendant and reset the case for a homeless calendar for September 10th, 2025 at 8:45 a.m. courtroom 6-8.
Your Honor, that was a RR.
Yes.
He's an add-on. Nothing on him. No, I was gonna give her the thing, but it's not, no.
And there's no stairway on his case, right? All right. Yeah, I guess it was a stairway from, I guess, where he was sleeping at. All right, is this Wayne Allen?
No, Your Honor, this is Mr. Carr.
Mr. Carr.
Your Honor, he's the last one on the list.
He was the write-in judge.
Do I have anything here? All right. And so for Mr. Carr, what do we have this morning? Is this? Is this just a warrant?
Yes, Your Honor.
Judge, can you call out the case number, please?
Case number M25-8307.
Thank you, Your Honor.
He's also being held on a felony for petty theft. He was given a $1,500 bond by Judge GLAZER yesterday.
Any sense?
If he was on felony bond, we're just gonna ask for a felony bond hold from yesterday.
He already has a bond, sir. State.
Did he post it?
No, he was given a bond by Judge GLAZER at bond hearing yesterday for $1,500. He's
So-
already being held for it.
Yeah, so it's just a felony hold.
There's no hold. There's no hold for the case.
There's no hold? Okay.
Yes, there's no hold.
So you're saying on this case, he was in court yesterday, or this is a different case? He has other cases.
He has another case, Judge, that he was already being held. He came in on.
Right.
On 8/7 for the felony case and the bench warrant. You're only setting the bond for the bench warrant.
It was just their standard bond.
That's
$500.
All right, so I got quash the warrant. And a bond of $500. But he says he's homeless. So are we resetting this for the homeless calendar as well?
Not at this time, Your Honor, if he's not being released.
Okay.
Judge, you're raising the bond to 500 from 150?
Yes.
Okay, thank you.
And who is this gentleman? This Wayne Allen?
Yes, Your Honor.
Okay.
Your Honor, Joanne Hennessy for the city of Miami Beach. At this time, this is the state's case, but there's a camping charge.
Okay, so it's got resisting without trespass, cannabis possession, and camping. And he's homeless.
Last time, cause they made me plead no contest last time, cause they knew they fucked me over. But then they did something like this, and then they made me not talk about neither one of them. Now I just had to go get me an attorney, but I've been working on it, so I'm cool with me.
Okay. If you have an attorney though, on your able to be with me, call that number because let the better feel that you don't need this.
Okay.
Okay, as to probable cause.
Yes, Your Honor. I would argue again that there is no probable cause as to the ordinance, and then as to the trespass after warning, there's no information within the four corners of this document that indicate that whatever signage was there was sufficient. There are requirements under the law. I can't remember the statute off the top of my head. And all of that then would go towards the officer not having a legal duty that Mr. Allen could resist. So I would ask that he is released outright, Your Honor.
Date.
The A form clearly states that the officer mentioned that there was a no trespassing Miami Beach sign prohibiting unauthorized access. Whether it is the legally sufficient sign, I cannot guarantee it at this time based on the A form, but there is a trespass sign, so I do believe there is probable cause to find trespass property after warning. Whether the state can prove this beyond a reasonable doubt, that is a question for another day, but there is probable cause to find that there is trespass.
And so as far as bond,
We're just gonna ask for a standard bond of $500 for count 1, count 2, count 3, and then for the camping of $150. For a total bond of $1,650.
And Your Honor, I would just argue that Mr. Allen is not employed at this time. He does not have a permanent address. So I would ask that he's released on his own recognizance.
all right, court finds probable cause as to count 1, set a bond of $100. That's the resisting without, it's the trespass, set a bond of $100. Count 3, RR, count 4, set a bond of $100. Are we resetting this for the homeless calendar, or he's not being released yet?
Your Honor, since he's not being released, we can't set it for homeless calendar.
Okay. All right, good luck to you, sir. And also stay away order from the 10th Street, Miami Beach. It's okay. This Mr. Gilliam?
Yes, Your Honor.
Okay, trespass.
And Your Honor, defense doesn't have a probable cause argument at this time.
All right, the court finds probable cause as to count 1. Any argument as to bond?
We can stick with standard bond of $500.
And Your Honor,
Defense?
defense would just argue that he is not employed, he does not have an address, he will not be able to afford bond, and non-monetary bond is the what is favored.
Court will set a bond of $100. Stay away order from Chili's.
Yes.
All right, good luck, sir.
100.
Yeah.
Or is it Sanchez?
And then, Your Honor, Mr. Sanchez requires the services of the interpreter.
Okay, Mr. Barron?
The next one.
Right, Mr. Sanchez.
State has no argument for bond, we can ROR this.
Or outright release, or this is when conducting a business check.
We believe there's probable cause, but we will stipulate to an ROR.
La fiscalía está dispuesta a estipular para la libertad bajo palabra.
All right, PC has to count 1 RR.
Yeah, thank you, Your Honor.
Fundado para el primer cargo y se le concede libertad bajo palabra.
And Your Honor, he does not have an address, so we'd be asking for a date certain on the homeless calendar.
Okay.
Le van a dar una fecha a continuación para el calendario de personas indigentes.
So, homeless calendar. September 10th, 2025 at 8:45 a.m. in courtroom 6-8.
Entonces tiene que regresar el 10 de septiembre a las 8:45 de la mañana en la sala 6-8.
Sí, de aquí. Está bien.
That's fine.
All right, good luck, sir.
Buena suerte.
Gracias.
Thank you.
And Your Honor, Mr. Brown also requires the services of the Spanish interpreter. Oh, no, my apologies.
Your Honor, Mr. Brown, is NBC reset for tomorrow?
That's not. So just reset.
That's number 17 as well. Okay.
What are we finding probable cause?
Your Honor, which case are we on right now? Mr. Brown has to be reset for tomorrow.
Yeah, reset.
All right, let's reset it for tomorrow.
Tomorrow, pay 18.
Okay.
That was the one NBC, remember the two she said that was detox.
That's the stay away.
I said, can you put medical? You say no, put NBC. 14 and 17.
And this is Mr. Sassy, Pablo Sassy?
Yes, Your Honor, and he requires the services of the Spanish interpreter.
Okay. Any argument as to probable cause?
Your Honor, defense would just argue that there is no evidence that this was drug paraphernalia possession with intent to use. An officer's belief that glass pipe is commonly used to smoke crack cocaine is not sufficient.
La abogada dice que no hay argumento para motivo, no hay motivo fundado y está argumentando de que no era parafernalia para drogas.
Your Honor, the officer in the A form states that in plain view of pedestrian and vehicular traffic, he saw the defendant smoking from a glass pipe, which is commonly used to smoke crack cocaine. And he did not lose sight of the defendant using this glass pipe. We believe there's probable cause, but we could stipulate to an ROR.
La fiscalía dice que sí hay motivo fundado, pero también estipularía para que se le dé libertad bajo palabra.
All right, court finds probable cause as to count one. When we release the defendant, RR, he's homeless, so we're setting a homeless count on her?
Yes, Your Honor.
All right, so
Entonces hay motivo fundado para el cargo, le da libertad bajo palabra y le reprogramarán para que regrese al calendario de personas indigentes.
So he's reset for the homeless calendar for September the 10th, 2025 at 8:45 a.m. Courtroom 6-8, Richard Gerstein Justice Building.
Tendrá que regresar el 10 de septiembre a las 8:45 de la mañana, sala 68, es la corte penal en el edificio Richard E. Gerstein.
An interpreter, if you wouldn't mind telling him, I'm giving him a document with that information.
Le dice su abogado, de entregar un documento que contiene esa información.
Tengo que ir a una corte.
So I have to come back to court?
Yes, sir.
Yes, on that
señor.
date.
Ahí, esa fecha, la fecha que aparece ahí tiene que regresar a la corte. Ahí está toda la información. That's fine.
All right, good luck, sir.
Se puede retirar.
Is this Jackie, is it Gleason?
Yes, ma'am.
This? Okay.
Your Honor, he also has an open felony. He'll be coming back on your bond hearing calendar.
Paperwork for the last defendant.
When, oh.
Alright, that's pretty awesome. Inside.
And so he's here on a bench warrant for petty theft.
Yes, Your Honor.
I could quash the warrant. And a bond of 3,000 last time.
That's the state position to keep that.
All right, set a bond of 3,000.
Your Honor, defense would just request that that is lowered. There is a felony case. You will have a bond on that. We would just ask that this bond is lowered. I'm not sure that he actually received notice. I don't know if he receives mail at this address.
I'll leave it as what previously set by Judge Harris. Good luck, sir. Oh, and it's also a stay away from the Walmart at 3200 Northwest 79th Street. Is this Mr. Ahmad? Is it Sahi?
Your Honor, reset for tomorrow, NBC.
What's tomorrow's date? 18th. All right, so is this Mr. Nelson, Michael Nelson?
Yes, Your Honor.
Okay. All right, there's petty theft. Kayla Descent, that's one I read already. Any argument as to probable cause?
None at this time, Your Honor.
Okay, so court finds probable cause, that's count one.
We're gonna ask for an elevated bond in this case. He has an open grand theft and burglary charge. So we're gonna ask to elevate it to $1,500.
Defense?
Your Honor, Mr. Nelson does not have a job at this time. He would not be able to afford that. We would ask that standard bond is what is set in this case.
What's the standard bond?
$500.
Set the bond at 750. All right, good luck to you, sir, and also it's a stay away order from Cole in Homestead. Madam Clerk.
Thank you.
Is this Mr. Preston Selling?
Correct.
All right, disorderly, intox, and resisting without violence. Or homeless. Putting unboxing gloves and
Been fighting people breaking in my house on in Miami. And they keep on attacking.
Right now.
Sir, I've appointed a public defender. You may want to take their rights and not make any statements this morning. Any argument as to probable cause?
Your Honor, none at this time.
And we're gonna ask for a standard bond of, excuse me, it's going to be $500 for the resisting and $150 for the disorderly.
All right, so probable cause as to count one, bond said was 500.
500 for resisting, for count one, it would be $150, for count two, it would be $500.
All right, probable cause for count two, bond 150. All right. And is there a stay away?
I'm sorry, Your Honor, I think you mixed the two charges up.
Okay.
Yes,
Count
this
one
one.
supposed to be 150 and count two 500.
Okay. So again, probable cause has to count one, set bond at $150. Probable cause has to count two, set bond at 500. Good luck to you, sir. Is this Sandy Camacho?
Yes, Your Honor, and he requires the services of the interpreter.
Awesome.
All right, good morning. He was charged with petty theft.
Buenos días, se enfrenta el cargo de hurto menor.
All right, any argument as to probable cause?
Not at this time, Your Honor.
All right, court
La
file.
defensora no tiene argumento para motivo fundado en este momento.
And we'll just ask for a standard bond of $500.
I'm sorry,
right.
Stephen Super, was it 500?
500.
Yes.
Got it, thank you, sir.
All right,
La-
so-
la- Go ahead, Judge.
Yeah, so the court finds probable cause as to count one, petty theft, set bond at $500.
Entonces hay motivo fundado para el cargo y la fianza se deja en $500.
And also stay away from the Old Navy, 17980 Northwest 27th Avenue, Miami Gardens.
También tiene que mantenerse alejado de la tienda el Old Navy que queda en la 17980 Northwest de la 27 Avenida en Miami Gardens.
Okay.
Okay.
All right, good luck, sir.
Buena suerte.
All right, this is Larry Knight.
Yes, sir.
Yes, Your Honor.
All right, good morning, sir.
Good morning, sir.
All right, resisting without violence, no valid driver's license, and like no motorcycle endorsement. All right, any argument as to probable cause? Let's see if he has. So this is only for, I guess, count one, resisting without violence.
They can't hear you.
My apologies, Your Honor. My microphone was on mute. I would argue that there was no legal duty in this case. It's required that there is an impact on traffic, and with regards to eye protection or helmet, there are requirements that the officer knows that this person doesn't have insurance and such. And so without the legal duty, there is no resisting without violence. So I would ask that he be released outright.
Your Honor.
State.
Your Honor, during the traffic stop, he told the defendant he was being under arrest and he shoved him and ran away, obviously resisting without violence. There's no way for an officer to know prior to a traffic stop whether a defendant has insurance for the items he's missing. So respectfully ask that there is probable cause and the defendant having shoved and running away, at which point the officer asked him to place his hands behind his back, counts as resisting without violence.
All right, court finds probable cause as to count one. Any argument as to bond?
Standard bond is fine, Your Honor.
The standard bond for count one for
Count one is the motorcycle endorsement would be 150, the no valid driver's license, which is count two, would be 150, and the resisting without violence would be count three, which is 500.
I have count one as resisting without violence. Oh.
Count one is 500, count two is 150, count three is 150.
This is the traffic.
Right.
That's the traffic count two. That's the misdemeanor, count 3. That's what that's in. It's got.
I'm saying when I'm reading here, the count one is the resisting without violence. So correct, what do you have as count one?
We have count one as the resisting, the bond is 500.
Okay.
Okay. All right, so we'll set the bond as the count one.
You just told him the same thing.
I don't know who's talking.
That's correct.
Oh. All right, so probable cause as to count one, bond of $500.
That's on the misdemeanor correction.
I'm sorry, what was that, Terry?
On the misdemeanor, the judge is putting the count bond at 500.
Okay.
Now we're going to the traffic.
And bond of 150 on each. Okay. Oh, you want me to call it out?
Yes.
The traffic ALIMNJE. That's no driver's license, bond $150. Where do I write it?
You just write it in. Bond.
And then the second one, ALIMNPE, also be bond of $150. Like I'm doing an eye test. Bye. All right, good luck, sir.
Your Honor, this is Joanne Hennessy from the city of Miami Beach. I'm only here for the misdemeanor portion of the calendar. Can I confirm the balance of the calendar's traffic?
I have,
Yes.
yeah, they're saying yes.
Thank
So
you, Your Honor. If I could be excused,
You may, thank you.
good day.
Okay, who do we have here? This is Mr. Perez.
No, Your Honor. This is Mr. Scans.
Okay, Daniel Scans.
Your Honor, for Mr. Victor Perez, he's reset for tomorrow, Ward D.
So Victor Perez is reset for 8/10.
Yes, Your Honor.
They're saying this was 8.
It's not.
No,
We can just put it right here into the place, reset, 8/10, 25. And so.
okay. And then Mr. Scans. Good morning, sir. What is this? A bench warrant?
Good morning, Your Honor.
What do we have here, state?
Yeah, he's on here for a bench warrant. I don't know what is the underlying charge.
It's my understanding that the underlying charge is a traffic offense.
That was here, correct.
All right, so what are you asking of the judge?
$7,000 bond. And you can watch the wall.
Okay. You're asking
Your Honor-
to quash the warrant, set a bond for 1,000, defense?
Your Honor, I'd be asking that he's released on his own recognizance. The address here is not correct. He did not receive notice. The warrant was only issued on 8/6. And so I got his correct address. I will make sure it's updated with the clerk reports, and he will be attending future court dates. I ask that he's released.
Looks like 8/6 of 2024, like a year ago. Is that correct?
I'm not sure, Your Honor. My notes say
Okay.
8/6. It looks like it's 2025, but I'm not 100% sure.
It says 2024 in the paper in front of me. Let's see, when was this ticket given? 5/13/2024. Arraignment.
Regardless of the date, Your Honor, I would ask that he's released on his own recognizance. I have the correct mailing address for him now. He will get notice of his future court dates.
In state?
We're gonna rest on our position that if it is, regardless if it was a year ago or a couple days ago, the bond of 1,000 should remain.
We don't have any record or anything for him. All right, I'll price the warrant, set the bond at $1,000. Where do I?
Go ahead.
This is Angel Carrasque. Carrasque.
And Your Honor, he requires the services of the Spanish interpreter.
Got it, thank you.
All right, so this is he's being picked up on a bench warrant.
Lo habían recogido por una orden de arresto.
State,
Interpreter can't hear the state.
He's whispering right now.
Oh, okay. Thank you, Judge, for the heads up.
Your Honor, this is, I believe, just a valid driver's license, if I'm not mistaken.
Correct.
Just standard bond of leave 150.
Por el cargo de no tener licencia válida para conducir, la fiscalía pediría la fianza estándar, que son 150.
I quash the warrant, set the bond at $150.
Entonces hemos anulado la orden de arresto y la fianza queda a $150.
All right, good luck, sir.
Buena suerte, señor.
And Your Honor, Mr. Simpson also requires the services of the Spanish interpreter.
And so what do we have here, State?
This is a controlled substance, for cocaine possession.
No, I only have, looks like 2 bench warrants for driving while license suspended and attaching a tag not assigned. I don't.
I'm sorry, Your Honor, the interpreter. Driving while license suspended and what else?
Yes, attaching a tag not assigned.
Entonces tiene el cargo, I'm sorry, the interpreter is interpreter, I'm sorry, please. Entonces, it's okay. Tenía 2 órdenes de arresto por manejar con licencia suspendida y también enfrenta un cargo por tener una chapa o placa de un carro que no está asignado a ese.
So State, what are you?
Just a standard bond of 150 for each count.
La fiscalía está pidiendo la fianza estándar de 150 para cada uno de los cargos.
All right, so order, quash the warrant, set a bond of 150 in case AL2FBOE. And quash the warrant, set a bond of 150 in case AL2FB1E.
Entonces, en ambos casos se anula o se invalida la orden de arresto y se deja la fianza de 150 para cada uno.
All right, good luck, sir.
Buena suerte.
Your Honor, for Mr. Simpson, that's 150 on each case, correct?
Correct.
Thank you.
No hablo español.
Sorry.
Is this Mr. Guardiola Gonzalez?
Yes.
Yes, Your Honor, and he requires the services of the Spanish interpreter.
All right, good morning, sir.
Yes, señor.
Morning.
All right.
Can I ask for a $150 bond on each count?
I'm sorry, what was that again?
$150 bond on each count.
Got it, thank you. $150 de fianza para cada cargo.
All right, so the court will quash the warrant in case ALWTY4E, set a bond of $150.
And Your Honor, defense would just be asking, Mr. Guardiola is unemployed. He is homeless. He will not be able to afford that bond. I ask that he's released on his own recognizance and set with a date certain on the homeless calendar.
Pues en el caso que termina en TY4E, se elimina la orden de arresto, la fianza queda para $150. La defensa dice, señoría, dado que él es indigente, estaremos pidiendo que le den libertad bajo palabra y que le den la fecha fija de cuándo regresar.
State?
After reviewing his priors, he could stipulate to $50 on each count.
I'm sorry, how much is in each count, please?
$50 on each count.
Got it, thank you. Entonces, después de mirar los antecedentes penales, la fiscalía estipula que se puede dejar $50 para cada cargo.
All right, court will reduce it in case ALWTY4E. Quash the warrant, set the bond at $50. And the second case, ALWTY5E. Court will quash the warrant, set the bond at $50.
Your Honor, these two cases are not bench warrants. I'm sorry, they're regular cases.
Okay, so just set the bond at 50 on each, no warrant being quashed.
Entonces se deja la fianza para $50 para cada uno. Y fianza anulada, la orden de arresto anulada.
Y me puedo ir y
Can I leave now?
el cargo. A mí me pagar.
So the interpreter just interpreting, Judge, but the interpreter was able to hear.
Will you just tell him that it's $100 total bond?
Es una fianza total de $100.
Y, ok, y no puedo ver un arreglo que pagarla por fuera, porque no tengo nadie así que me pague así.
I mean, how can I go about paying that? Because I really don't have anyone that can pay it on my behalf.
Somebody will explain it to him.
Más adelante alguien le va a explicar.
Okay.
Okay.
Is this Mr. Bartholomew?
This is Mr. Bartholomew, Your Honor.
Right, state.
Just a $150 bond on the NVIDIA.
Okay, as to case ALXYDSE, court sets a bond of $150.
Can I get a hold up, sir?
Your Honor, I would just ask that in this case, this is not a violent offense. This is a no valid driver's license. I would ask that he's released on his own recognizance as non-monetary bond is preferred.
The court will keep the bond at 150.
Even if I got written.
And Your Honor, Mr. Castro, or my apologies, Mr. Dieguez would require the services of the Spanish interpreter.
Your Honor, he also has a hold for immigration.
Que también tiene una orden de retención de inmigración.
Right, so state.
We would just ask for a standard bond of 150. But there's a nice hold.
He has, I'm sorry, because he has two cases here. Looks like, is this the same?
Yeah, that's it, yeah, AKA, I was told. Aspiration.
Oh.
Tiene dos casos, la fiscalía está pidiendo la fianza estándar y que también él tiene una orden de retención de inmigración.
I set a bond back in 2018 in this case.
En el 2018 yo ya había fijado fianza por este caso.
So we have three cases.
Say we'll just ask for 150 on each. On the bench warrant.
It's 3 bench warrants, I'm sorry.
Okay, there is, you're right.
Tenemos aquí tres casos, tres órdenes de arresto de 150 cada una.
Now it's telling me that there's a note on this case, Gumberto Rodriguez. So this note says that this case does not belong to the defendant on calendar. Two different people, different date of birth, not the same name. this should not be addressed.
Your Honor, for that case, that's an AKA.
But who wrote the note that it's not the same person? Huh? Oh. So it is the same person. All right, so as to ALWTYKE, court will set the bond at $150.
Your Honor, that's TYQE.
Yes, I'm sure that's what I meant to say. ALWTYQE.
Okay.
Entonces, para el caso que termine en YQE, la fianza queda a $150.
All right. And as to the bench warrant on AH3FZKE, the court will quash the warrant and set the bond at $150.
En cuanto a la orden de arresto por el caso que termina en CKE, vamos a eliminar la orden de arresto y dejar la fianza a 150.
And on the bench warrant on AHHAE1E, court will quash the warrant and set a bond of $150.
Y en cuanto al caso que termina en W1E, este despacho va a eliminar la orden de arresto y dejar la fianza a $150.
And the last case is A2E V0OP. Court will quash the warrant and set a bond of $150.
Y en el caso que termina en B0OR, de nuevo, este despacho va a anular la orden de arresto y dejar la fianza a 150.
Your Honor, the bond for the E1E, that was 150 as well.
Yes.
Thank you.
And Your Honor, Mr. Yosny Izquierdo does require the services of the Spanish interpreter.
He's asking for a $150 bond on this account.
Your Honor, he has a related felony. He'll be back on your bond hearing calendar.
Entonces, una fianza de $1, dice el departamento carcelario, él tiene un caso de delito grave también y regresará para el calendario de delitos graves o delitos mayores.
Okay, so as to case ALXQ6NE, court sets a bond of $150. As to the citation ALXQ6JE, the bond of $150.
En cuanto al caso que go ahead, Judge.
As to the citation ALXQ6PE, the court will set a bond of $150. And I think that's it, right?
Entonces, en el caso que termina en 6NE, el juez va a dejar una fianza de $150 para la infracción de tránsito que termina en 6JE, fianza de 150, al igual que para el caso que termina en 6PE, fianza 150. Yeah, no, just to confirm that there'll be a traffic infraction, right? You said the citation is that the traffic.
Yes.
Because interpreted as a traffic infraction. I want to make sure that I did it right.
Okay.
Yeah, thank you.
Is this Mr. Juan Gardarama?
Would you like them to interpret
Yes, Your Honor.
State's asking for $150.
All right, on this citation, AM1R7NE, set a bond of $150.
Your Honor, he's also a VFox.
What is that? What were you saying, corrections? I wasn't,
Your Honor, I believe he has another hold.
okay.
It means violent
Offender.
offender of special concern.
Okay.
No bond, Your Honor. So, yeah, we'll keep the 150.
150 on the traffic and the other, I guess, case.
Your name? Are you Mr. Lanza Gomez?
All right, so this is Mr. Isaac Lanza Gomez.
Yes, Your Honor. And Your Honor, he requires the services of the Spanish interpreter.
Hey.
We're gonna ask for a $150 bond.
I'm sorry, State. Can you get closer to the
Yeah,
microphone, please?
Sorry, $150 bond.
Got it, thank you.
Okay,
Una
so,
fianza de $150.
so in case AI71RZE, set a bond of $150.
En el caso que termine 1RZE, dejamos la fianza de $150.
And this Mr. Nerby.
Okay, how are you?
Yes, Your Honor, he's present.
All right. Date.
This is for a bench warrant, but he does have a valid license, so I do not know if the traffic case.
You're saying he has a valid license?
He does have, it does say his license is valid now, but
Mhm.
I don't know if this is a NVDL or DWS have that information.
Well, this says no vehicle registration.
Support on Monday, they never.
Displaying of a fictitious Florida tag. That's what this says on the citation.
Then I guess our standard bond for this would be $5,000 for this bench warrant.
And Judge Silver. State you're asking for a $5,000 bond?
Correct.
Your Honor, defense would argue, I have spoken with Mr. Nerby. He said that he did not receive notice about this court date. The address is correct. I'm not sure why he was not properly noticed, but I'm asking that he's released on his own recognizance.
I'll quash the warrant. I'll set a bond of $250. Is this Mr. Stockwell?
Yes, Your Honor, he's present before the court.
And state would just be asking for a $150 standard bond.
Okay, in case AKGLX8E, set a bond at 150.
Your Honor, I would just be asking that Mr. Stockwell is released on his own recognizance. He has some medical issues and a non-monetary release is preferred.
State.
And I would also argue that this is a driving offense. I don't think that he needs to stay in jail any longer on this.
They can stipulate to reducing the bond to $50.
And Your Honor, I would argue that $50 for 150 is not that big of a difference. It still requires that he finds money to put in the account to pay bond. A bondsman will not take somebody on for $50. If the state is willing to stipulate to $50, I don't know why he can't be released on his own recognizance.
Well, I mean, the citation says he admitted to knowingly driving with his license suspended. Let's see. Commercial license was around. All right, I'm willing to reduce it to $50. Good luck, sir.
Salad? You speak English?
Yeah.
Okay.
And this is Deshaun.
No, Your Honor,
Okay.
this is Mr. Gonzalez.
Okay.
Manuel Gonzalez.
Billy and Jen Pop.
Oh, let's see. All right, I got Manuel Gonzalez here. Manuel Gonzalez, 4 new cases. And DUI, property damage. Driving while license suspended. Refused to submit.
And Your Honor, as to PC, I would just argue that he cannot be convicted of all of the DUI charges. So I would ask that if bond is set, it is only set as to one of those. I'm not sure which the state is going to proceed on. That's in their prerogative, but he should not have bond set to all of them.
Well, one says DUI misdemeanor, the other says DUI property damage. I don't know if there's separate elements in each of those.
Your Honor, the state's position is he can be found guilty on every charge. charged with. And so we'd just be asking for standard bond, after reviewing his priors, we're just asking for standard bond of $1,000 on count one, $1,000 on count two, 150 on count three, and 150 on count four.
All right, it'll be ordered. So on case AD07DNE, that's a DUI misdemeanor. Took bond at $1,000. In case ALXQB4E, which is DUI property damage, personal injury, set a bond $1,000. On case ALXQB7E, which is driving while license suspended, set a bond of $150. And on ALXQB5E, refusing to submit to blood alcohol test, set the bond at $150. All right, good luck to you, sir. I still have a few more here. Do we still?
Two more, but
Okay.
Billy and Botox.
Right there.
Mr. Gene Poits is a bond out. Also, Mr.
Billy.
Wilfredo, somebody. Gutierrez Vasquez is a bond out as well.
What about Mr. Philly?
He's en route. He's coming.
Okay.
So
You could just pass me,
this-
jump out.
that bond out?
Yes. Thank you.
And I have this here. What did Madam Clerk? I don't know why I didn't sign it. I don't remember.
I got not.
Right. And they'll say Mr. Seeley's on his way. And then we got felonies and that's it. That looks like a big stack over there.
We only have 41 defendants for the.
She's been a little off the bars.
But I know if they came in there when I was in there. Or the, PM, I did the PM. Yeah, however, when she came, I was gonna get on meeting, I told her that boss that she had paperwork from, yeah, he was. And she was, how come you?
We're still waiting on Mr. Sealy.
Is there like a weekday?
He's en route, Judge. He's coming.
Right. I don't see. Oh, yeah. Sure.
Yes. Slash your word, that's where you from? You know the words. Oh. But I think there was some time this ran for filming, I mentioned something, I was like, oh, you can. Yeah. I actually we stayed in Jersey. I saw them. Yeah, that's what she's so close to the city. Yeah. Go say where I become a married, so I'm like an hour from this. I think we missed that. That statue is, we was over there. Nice. Yeah, we had a good time. I go all the time. Yeah, they've been again. Yeah, my baby was there. Oh, yeah. My mom goes with my mother's. So yeah, right now. Every week she used to go. I know she feels like it. Exactly, he plays one. It's almost so. Yeah. I know this was slow paced and moving. It still is. So especially when I'm driving. Yeah. Makes you crazy. I want people over that. Obviously, it's great.
All right, is this Mr. Sealy?
Yes, Your Honor. He also has an open felony. He'll be back on your bond hearing calendar.
Okay.
Excuse me, sir. I don't want anyone to represent me, and I'd like to speak for myself.
So right now, the public defender is appointed to represent you at this
No,
time.
I did not sign any papers for any public defendant to assign to address me. I have the right to represent myself. That is the Sixth Amendment. I know the law, and I'm here to address the law. I would like the same respect as the public defender, as a prosecutor, and I would like my knowledge of the law to be acknowledged. Did you read the A form yet, or
No, we're not here on the felony. We're just here on the traffic citation.
a traffic citation?
Yes.
Okay, so we could address that. So I went to I had a text.
Sir. I understand that you want to represent yourself, but representing yourself can
Yes, I
there's a lot,
represented myself
sir, there's a lot of potholes and everything that you could be falling into by trying to represent
know-
yourself. I'm
I'm
gonna give you
aware.
your advice that you should remain silent. I understand that you do have
aware.
felony cases forward. I understand everything that you're saying here right now is being recorded. and you
Yes,
could say
yes, I'm
something-
aware.
I understand, but you know, so you have the right to remain silent, and anything you say is being
And I
recorded.
do have the right to be heard as well.
Thank you. Well, I have not gone over.
I'm fully aware of the law, and I just like to speak.
Sure.
You said we are going to address this bench warrant. Now let me address the bench warrant. Can I do that?
Look, I have not gone over the criteria of whether or not you are competent enough to represent yourself. This is just really a bond hearing, so generally, but if you don't want the public defender to speak on your behalf, then.
Is it not the Sixth Amendment for me to right to represent myself? I'm just trying to speak and represent myself. That's all. Can you allow me to do that, please, Your Honor? I know the law. I studied the law because my rights were violated, and I didn't like that.
Wait, what do we have here in this case?
It's on warrant for disobeying police, fire, and I'm assuming the total bond amount would be $3,000.
Is that the standard bond for this, or is this part of
This could be the
the?
total bond.
Hey, can you speak in the mic, please?
This could be the total bond for his all, including his felonies. It could be
But-
3,000.
Failing to appear for his jury trial.
Okay,
Excuse me,
so
sir.
then it would be 3,000 for the disobeying the fire police bench warrant.
Okay, so
All
may
right.
I speak now, please?
Certainly, sir.
What did you say?
I said certainly, go speak if you
Okay,
wish.
so I woke up in the morning saying that I had a bench warrant text. I called the judge's chambers and I went on Zoom. They did not let me in the Zoom. They did not let me in the courtroom. Then I had a confrontation with the police officers while I was getting food at a Jamaican spot. They said that I had a warrant. Please, can you please not interrupt me? Okay, so boom, I had a confrontation with the police officers at a Jamaican spot where they said that I had to leave and they said ask me for my ID. They seen that there was a bench warrant and they arrested me for this same bench warrant. Then I explained to the judge what had happened, and they do have record that I attempted to go to the courtroom, that I attempted to go in the Zoom, and they just didn't let me in. So the judge RR'd me based on that information. Do you have that same information that I did attempt to go here and I'd already got arrested for the same bench warrant? So
No,
it's like-
I don't have that information, sir.
So
Hold on, let me ask the state. Maybe the state has that information. State, do you have any information?
Not at this time, and
they don't have an arrest record of me being arrested for this bench warrant already?
We have your arrest date being yesterday for this bench warrant.
No, there was arrested. I got arrested and I was out on pretrial for this bench warrant. I'm not sure what's the issue is. This was documented as well. I was in misdemeanor court. This was also documented. And I was on camera in the courtroom on last week Friday. Or the other Friday or whatever when this issue happened. I was in the courtroom on camera. And I was in a Zoom, so I have proof that I actually showed up. And I still got arrested. And now they're saying that this bench warrant is still open. Can you guys investigate this, please? And like,
Hold on for a
We
second.
have on July 29th, you failed to appear for your jury trial, and a bench warrant was issued and has not been set aside yet. So no judge has, if you did appear, no judge has set aside your bench warrant.
And why did no judge? Because I had court. I had court with the judge, Carrera. Someone was replacing Carrera at that date that I had court, and I explained fully in detail with that judge that was replacing Judge Carrera exactly what happened, and he said that I will get a new court date in court and to call the court after a week. So this is all documented. The same way this court appearance is recorded, that court appearance was recorded. The fact that he rescheduled me. Why did he reschedule me instead of uplifting the bench warrant after I already addressed it? I actually tried to attempt to go to the court, and I even went on Zoom. I have a screenshot on my phone. And I got arrested for the bench warrant, and I addressed it with 2 different judges. So it's like, what's the problem? What can y'all find this evidence? Because it's on a recorded courtroom. I
Even
told the
if you
2
did-
judges
All
about
right,
this.
all right,
Even
hold
if
on. State,
Okay.
you have any additional information?
Even if he did speak to judges, they did not quash the warrant. So
And why is that? I'm liable to be arrested. Okay, I'll listen.
Well, what I'm saying is that the state, his officers of court are saying they don't have any information that this warrant that was issued on July 29th, a couple of weeks ago, has ever been set aside or quashed by any courts.
Do you have any evidence of me actually having court? That's what they're saying.
No, I don't have any evidence. This is just a bond hearing, sir.
So why did I get released for pretrial on a bench warrant?
Corrections,
The public defender's office should know this as well, because I called the public defender's office. I called the judge's chambers, judges you Bastando, Judge Carreras Rivera, judges chambers. I even logged in on a Zoom, took screenshots. All
Well,
of
you
it.
have a
So it's like,
representative
if
of the
I'm trying
public
to go in the courtroom and I even got arrested for the bench warrant already, and then you guys have recorded court. Like, what's going on here? Because I already got arrested for this bench warrant, and you guys, I'm literally on the same camera with the female judge. She gave me pretrial for this bench warrant because I already attempted to go in the courtroom, and I had record of this.
All right, so this is just a bond hearing. I'm sure there'll be a lot other court hearings that will come.
Yes, and
that which you'll be able to explain and get your evidence.
Okay, so what I'm saying is the felony charges. So that is against the equal protection rights. So that all those charges needs to be dismissed because
All right,
if
well,
they
I'm not dismissing any charges today.
Okay, well, may I have overall? May I
sir?
explain to you how they violated my rights?
No,
Because you have that right.
not today. So I'm gonna leave the bench warrant on for that case. For 3,000, and then when your felony case comes back up, I'll look at those charges at that time.
But I have bond arraignment for the felony case, right?
I'm not sure. I don't have the felony case in front of me yet. They're gonna bring it up in a few more minutes.
In a few more minutes?
Yes.
Okay, so with the bench warrant, can you please give me a pretrial RL like the last judge? Because there still be no reason why I'm having to pay if I already went in there.
Well, let me see what the attorneys are saying on the felony case when they come to address it. Again, you talked about a public defender. You do have one present, but you're saying you don't want them to represent you. So if you don't allow them to say anything, then maybe I won't know what happened. So maybe they can help you out. Why don't you give them a minute?
Find out record of me
Sir?
being in the courtroom or me being arrested because I was on the same camera.
All right, but give her time.
I was asking her.
But you got to give her time. She's been standing here. She's been here all morning.
Yeah, I know.
On so many other cases.
I know. She never tried seeing me.
Before your felony case gets called, we'll take a break and maybe she'll do some looking for you and she may have some more information at that time.
So once you guys do find the evidence that I did go to court, you're gonna give me pretrial?
I'm not making any promises, but I'm
All right,
saying
cool.
you at least have the
Fine.
time to look
Let's
at
do a
it. And
reset.
then we'll,
Thank you. I understand.
all right, sir.
A few minutes, right? So a few minutes and then we go to the
Just a
felony?
few more
Okay.
minutes, and I'm gonna keep the public defender on your case. Let me take a moment, I guess.
Excuse me, Judge? Yeah.
Okay, we can, ready to do these,
Recording in
this
progress.
afternoon cases, felony cases? Correction, are you ready?
Yes, Your Honor, we're ready. They need to be
Okay.
sworn in.
All rise and please raise your right hand.
Todo el mundo de pie, levante la mano derecha.
They don't have the camera.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? If so, say I do.
Bueno, prometen que el testimonio que va a presentar va a ser la verdad, solamente la verdad. De ser así, digan que sí.
Corrections. This is video. We cannot see the. Oh, there they are.
I still can't see. All right, so do you want to swear him in again, or?
Judge, the judge needs to hear you all say I do. He did not hear you all say it.
That's sufficient, Your Honor.
All right, we'll go ahead and get started. They've all been sworn. And public defender is appointed if not previously mentioned.
Good afternoon, Assistant Public Defender Alejandra Preciado on behalf of the PDs.
We're gonna start on page 12, Judge, Mr. Armstrong.
Mr. Armstrong.
I will help you right now with that.
Okay. This Donald Armstrong.
Yes, he refused court reset for tomorrow.
Oh, that's like.
Let us pull the A form first.
Excuse me?
What number he is?
37.
I got a memo about.
As you write on the back of the first page of the A form, you see found, that should be about, you make me reset.
Okay. All right, so the case of Donald Armstrong.
Refused court reset for tomorrow, Judge.
All right, but the court is still gonna find probable cause based upon the A form. We'll deal with the issue of bond tomorrow then. Where do I sign? Where do you want me to sign?
Right here.
No, he does not.
Just write RS or reset and tomorrow's date, Your Honor. And put PC found anywhere.
And we're doing 37 on down, Judge.
You should have told me. Oh, give me a second, Your Honor. I'll pull it now. You shouldn't. What's the name of the?
What's the name? Oh,
Turn the page, turn.
okay, 37, there we go. It's
No deal with it.
Alexander Trago? Is that who?
Refused court reset tomorrow.
Okay. So the court's gonna find probable cause reset for bond determination tomorrow, based upon the A form.
Do you repeat that, Your Honor?
The court is finding probable cause based upon the reading of the A form, and we'll set it tomorrow for issues of bond.
Judge, do you just want to waive presence in that instance then?
The defendant waived his own presence.
Judge, then we could set the bond today.
If
No.
the public defender waives the the defendant's present, so you can settle bond if you'd like to go.
But I don't know if that's what the state actually wants to do.
You said it till tomorrow.
Okay.
So I would ask that PC is not found.
No, I'm finding PC. I'm not allowing him to refuse to come and then somehow then claim to be able to be released RR because no PC was found within the 72 hours of his arrest.
He would be
Can't
here
have it.
tomorrow, Judge.
Okay, so, but I'm gonna find a PC today just in case tomorrow he doesn't show up. All right, so these are all. Was that more? Okay. Okay. So who are we calling next?
Mr. Galvez, reset for tomorrow, NBC.
It's number 38. Okay.
Number 39, Galvez.
It's an Eduardo Galvez, right?
Yes, reset NBC.
DC is found. Reset. This one. All right. Are we calling anyone else out of turn? Mr. McMillan, counsel, did you have them pull your client or?
Judge, I put in the chat that I have Luis Fernando Garces, F25170.
Okay, we'll look and see if we can pull your client.
Mr. Tosco Gomez, reset NBC.
Okay. DC found in the A form, reset.
Mr. McCreef, refuse court, reset tomorrow.
Okay, hold on. So, I have to have. He's reset a few times. Hold on. But reviewing the A form.
And Mr. Dent, reset NBC.
PC's found, cases reset for tomorrow. Hold on. This. And then Mr. Dent.
I have argument for this case, Judge, since you're finding probable cause based on the reading of the arrest form, even though client is not here.
Let me read it. Let's see if upon arrival, fight took place in a cell. Footage depicts the penalty.
And Your Honor, if counsel could repeat the name of his client, I lost track of where it was.
This one is Mac Charles Dent.
No, the one that attorney on Zoom was looking for.
Oh, he put it on the chat. Luis Fernando Garces.
It's number 4 on the list.
Okay, thank you. Counsel, as to you were saying probable cause? They were fighting
Honor,
on the video.
The way that the arrest form reads is that there's a verbal argument that ensues before the alleged physical overt act. We don't
Okay.
have any information of what that was said. However, I was here, I spoke with Mr. Dent this morning. He did indicate to me that he acted in self-defense because he felt in fear of his safety. That's why I was asking for this court not to find PC on the cases where my clients aren't here so that they could also hear me make these arguments, Judge. But based on the fact that there's a verbal that ensues before the physical act, I'm asking this court find that there's no PC given the self-defense.
If I may, Your Honor.
Yes.
ASA Colonel Mead on behalf of the state. It appears in the arrest form that the defendant explains to arresting officers that the reason for the fight was because he did not want to have a conversation with the victim. He further advised that he pushed the victim because he wanted his space. It doesn't indicate that he was in fear in any sense. Also, as indicated in the arrest form, the CCTV footage depicts that the defendant was the initial aggressor. And although there was a verbal dispute, he was the one who became physical initially by pushing the victim.
All right, court finds probable cause based upon the A form. All right.
And you're still gonna reset for tomorrow, right?
Yeah, because he has a right to be present, but if he keeps waving. All right, so we have any, what do we have next? Mr. Garces. Corrections, do you have Luis Fernando Garces?
Yes, Judge.
Okay. Counsel, give me a moment, I guess. Okay, they have him here. Let me read the A form. He's charged with threats, aggravated stalking.
Your attorney's on Zoom, sir.
Oh, yeah.
Yes, he's here.
Oh, thanks, God.
Just let him make the
The
argument.
added charges, Judge.
His name is Larry McMillan.
If you want, but it's the same screen. No, I hear you. No, it's just so he could see his attorney on my screen because he can't see it up there. It's a little far. Thank you, Carlton. Or you're muted. Yeah, I got you.
All right, and any argument as to probable cause?
Judge, I requested the arrest affidavit this morning from the clerks, have not received it, but I can tell you that I spoke to the arresting officer yesterday, and I was also provided a copy of the injunction, and I read the narrative of the victim, which I believe is the basis for the two charges here in the arrest affidavit. So I'm at a disadvantage. I don't have what's in the A form.
All right.
I can tell you this, Judge. He's out on felony bond on another case, and he's set Tuesday in front of Margie Verdi in mental health court.
All right, state.
Yes, Your Honor. In this case, the state would be asking for $7,500 each count.
Court does find probable cause based upon the reading of the A form. Any argument as to bond, Mr. McMillan?
Judge, is that the standard bond for the stalking charge and the extortion?
I don't believe there is a standard bond set. It has to be set by Your Honor. But that's the state's recommendation because it follows along suit the other typical bond amounts for charges similar.
And he was, and what was he out on bond for? This
Arson, Your Honor.
same victim or?
No, Judge.
Arson, threats, extortion, okay. All right, court finds probable cause, has to count one, set the bond at 5,000. Count two, set the bond at 5,000. And it's also a non-domestic stay away order from the victim. All right.
Correct. Judge,
Good
if
luck.
the clerk-
Okay.
I'm sorry, if the clerks could set it over to Judge James on Monday.
It will be.
They say it will be.
Yeah, because he's got a hold. Okay, nice to see you, Judge. Thank you very
All
much.
right, you could, okay, thank you. Thanks for being
Lewis,
patient.
hang in there. I'll see you Monday, Lewis.
Says Judge Alfield, Billy Alfield.
Alfield is on the new case, 17062, but the old case is Zachary James, F25 9119 is Zachary James.
All right, they're gonna verify for you. Let's see.
And state or the clerk, if somebody could email me the A form, that would be tremendous.
Can't send out A-forms anymore, Your Honor.
She said they can't send them out any longer.
I know, but you can still ask.
Is that, Dennis Hewson? Is that, no?
That's
They're not quite sure who you said in front of next. Oh, okay. The Division 55, okay.
That's going to be Margie in mental health.
Okay.
I think that's Verde.
Okay, Maria Verde.
Maria Verde. Okay.
All
Judge,
right. All right,
great
good
to see you. Thank
Okay,
you.
take care.
Bye.
All right, so we're back on.
Number 18, Your Honor.
Wait, hold on, you guys didn't. I have not pulled that.
This is Mr.
The carried over from this morning's county calendar, Judge.
You need to call over there.
Correct.
Who's number 18? Oh,
Hmm.
Abraham Alfonso,
No, Judge, the one previous.
Deshaun Sealing.
That's
Yes.
correct, Your Honor.
Permission to speak when you give
Hold
me a
on,
chance? Yeah.
hold on a second, because I have it at 17, I guess they. Hold on, let him get the paperwork.
Of course, good.
Six.
Okay, let me get a chance to read this A form. Charged with sale of cannabis, tampering physical evidence, possession of cannabis, possession within 1,000 feet of school,
Let me announce that you don't want me on the.
resisting without violence and smoking cannabis on, I guess, public property. Let me read the A form.
And Judge, before you read the arrest form, I know this morning you said that you would appoint me on all the cases. He's represented to me that he does not want the public defenders. So I ask that this court not appoint us for the purpose of this particular individual, Your Honor.
Well, I mean, I didn't go through,
Yeah.
a full hearing on, his ability to truthfully represent himself. So I was just appointing a public defender for the purpose of.
I'm fully educated on the
Parents.
law and I know exactly the laws pertaining my case. And when you give me the chance, I will explain this to you, how the police violated my rights. So you could read the A form however you want. And then when you're ready, I will explain to you exactly the laws that the police have broken.
Judge, if you want, I think what the best plan to be would be to set a Feretta for division judge this week. Because
Right.
I can't be appointed on the case for a client that continues representing that he wants to go pro se, Your Honor. He has the right, if that's what
Yes.
he wishes to do.
Yes.
Well, he can certainly.
have the right to speak
He has the
right
right
now,
to speak.
too.
He has the right to speak on his behalf.
Yes.
So if he wants to speak, going against the advice of counsel that's been appointed, then.
Judge, then I'm going to make argument for this court not to find probable cause, since you are appointing me, even though he's saying that he does not want counsel, Judge.
Okay, hold on for a second, but, oh,
He orders me to stay on the case. I cannot go over.
all right,
with it.
hold on, give me a
But I
chance
can still speak, though.
to read the A form.
I understand.
But I'm just letting you know so that you know.
Your Honor, may I
Hold
tell
on,
you something? Okay.
hold on for a second, sir.
Okay, okay.
Wearing a purple shirt and smoking a cigarette as officer approach. Cigarette into the storm drain. All right, I've read the A forms, sir.
All right, so I would like to tell you that I own a clothing brand. I just did a photo shoot. Now, before you stop me, I just did a photo shoot Tuesday for my clothing brand. Wednesday, I just did a
Why is that?
commercial.
But that's, we need to focus on.
If you
that's
listen,
the
yes,
charge.
if you
Sir, I
listen to
don't
what
have, I don't have all day, sir. We
yes,
just
yes.
don't
If you
go
listen to what
to-
I'm saying, if you listen to what I'm saying, then you'll understand how everything is put into place. So I just did a commercial and a photo shoot for my clothing brand Tuesday and Thursday. Friday, I get arrested. Now, what I'm saying is, okay, so boom. What I'm saying is that the reason why I've been mentioning the clothing brand because I had money on me. The money was before me selling my clothes on the street. I even had two products in my pocket. The two products is listed on my website. I have orders to fulfill. I'm the only one that's working my business as well. The products was in my right pocket as well, and it was never mentioned. However, it's in my pocket. I was on my way to go drop it off. I have orders, so people buy t-shirts from me, people buy gym suits from me. Sometimes they pay cash, and I can show you, have proof of that inventory and everything, just in case you want to try to label my hard-earned money as drug money, because I do have a registered business. I do have a website for that business as well. And I have been fulfilling orders as well for that business. With that being said, so what I want to address is that this is not the first altercation with these two police officers as well. And this is selective enforcement. And also, because if you like, I would address the other two incidents. This officer Dominguez had walked past me on Ocean Drive saying that thank you for the tip. Now, whole time I never spoke to this officer, never approached this officer ever. So then I walked back to this officer and then put my camera on his face and said, "What tip did I give you? I didn't give you any tip." While he was talking to other officers. Now, boom, I was followed.
Sir, you're
Yeah.
getting beyond what I need to do today. All I need to do
Okay, all
today
right.
is
So let me ask you
determine
this:
whether or not
we can
there
go
was
straight
probable.
forward.
Hold
Do you
on.
have do you
Sir.
find probable cause?
You haven't finished speaking, so I can give the state an opportunity to make their argument. But you started talking about the incident, okay, but then you started going further and further out,
Yes,
which is
because
not
I'm
going to be
explaining that
relevant.
they have personal vendetta, and this was selective enforcement as well, and I could explain that in detail. But if you
Right,
want,
but we don't have the time for that.
all right,
That
so
would be a
let's
defense
get
that you would
straight
have.
to it. Do you find probable cause?
All
And if
right.
you find probable cause, then I'll tell you the laws that they broke and specifically.
All right, hold on. State,
All
what
right.
do you want to say?
Yes, Your Honor. In the four corners of the arrest affidavit, the state would see that there has been probable cause for all crimes charged in this case. If Your Honor were to start with charge or count one, which is the sale of cannabis, on the second page, third paragraph, it will show clearly where the officers indicated their probable cause for that charge, saying that he had a wad of cash on him, also combined with the currency combined with the packaging of the marijuana is consistent with street level sales of cannabis. So that would be charge one. The tampering with physical evidence, it indicates on page one going into page two that the defendant dropped the marijuana cigarette into a storm drain. And for count three, possession of more than 20 grams. And on the second page, third paragraph, there were 17 individually packaged Ziploc baggies containing a green leafy substance, the total weight of approximately 132.4 grams. And the state believes that, lastly, count four, which is indicated on the fourth paragraph, he was, or I apologize. Yes, the fourth paragraph, he was within 1,000 feet of Loomis Park. Therefore, as per the arrest affidavit, it appears that all, that probable cause is shown for all charges.
May I state my argument now?
Judge.
I thought you already made your argument.
No,
Public defender.
I asked if you have probable cause, and if you had probable cause, then I explained to you the laws specifically that the police officers
All
violated.
right,
So do you have probable cause?
I am finding probable cause as to
And
all
what is the
four
probable
counts.
cause so I can explain this? Because
Sir, I find
yeah.
probable cause that you have committed the crimes in which they allege that they
What is the
arrested.
okay? So based on the smell of marijuana, you cannot find probable cause because they sell weed in the store. So if I could legally purchase marijuana in the store, then I could legally smell like marijuana on private property. Now, what I'm saying is this A form said that he said he spotted me smoking a marijuana cigarette, right? So how did he spot me? 50 feet away. He was at a red light on 10th and Collins. At a red light going westbound. I was 20 feet away from the corner northbound on Collins when he seen me smoking. So if he seen me smoking, right, and it was almost done, if he seen me smoking, how does he know what I was smoking? And what gave him that right to come and conduct an investigation? They have tobacco being rolled on Ocean Drive. So now, if they could smoke the tobacco on Ocean Drive freely without, listen, without the police grabbing them and arresting them, then I can smoke my tobacco freely because it was tobacco. And I said to the officer that it was tobacco, and he has no proof that it was any type of weed at all, nor can he find any proof. And based on that, based on the fruit of the poisonous tree doctrine, it is illegal to use any illegally obtained evidence against me and on the exclusionary rule. So any illegally obtained evidence used against me cannot be used against me in a court of law. So all that they found cannot be used against me at all because he wrongfully searched me. He violated my due process by grabbing me. He violated my rights. He violated my rights. Why did he grab me instead of approaching me? And all that time, I already dropped it because it was done. I was done smoking my tobacco. So I had every right to drop it. I had every right to drop it. It's not tampering with evidence if I was done smoking it, and it's tobacco. And he can't see through a tobacco leaf. He doesn't have X-ray vision to say, okay.
All right, sir. You can file your motion to suppress the evidence if they ultimately charge you.
But what I'm saying is,
if they charge you with these crimes, and then you can file. And you can file your motion to suppress. You can file. All I'm doing today is determining whether there was probable cause.
And I explained to you that they can't find probable cause.
Right, but I'm presuming what the officers say is correct, and I do find that there is probable cause.
It's his word against mine. How is this probable cause? Okay, so boom,
sir.
Do you know what the equal protection rights is?
Sir.
Yeah.
My job to make those decisions. They're not easy ones, but you have other chances to argue them. Okay.
Do you know what the equal protection rights is?
Sir, we're not here talking about equal protection. We're talking about probable cause.
Yes, we are, because if my rights were violated, then I have the right by 6th Amendment. I have the right to address that. I'm addressing that now that the police violated my rights. So
but if your federal right, that would have to be filed.
You'd
have to file it in federal court. You'd have to file it in
what I'm
federal
saying
court.
is the police violated my rights by approaching me to smoke or something when he never even knew what I was smoking. Why did he approach me instead of anyone else? He was 50 feet away. The A form, they clearly said that he spotted me smoking a marijuana cigarette. How did he know whether it was marijuana or tobacco 50 feet away? You can't find probable cause for that. He can't smell 50 feet away at all. And even if you want to say smell marijuana, I can legally purchase marijuana, THCA.
I have found the probable cause. We're now going to set the bond. You will have your opportunity to make those arguments to the division judge or to a jury when your case, if your case ever gets filed.
I'm letting you know by law.
Your Honor, if the state may give their suggestions for the bond amount.
Yes.
The state would be asking in counts 1 through 4 to set a bond of $2,500, and counts 5 and 6, the state is fine with standard of $500 and $150.
So it's saying for count 1, 2,500, count 2, 2,500, count 3, 2,500, count 4, 2,500. Said count 5, 500, and count 6,
150.
150.
Thank you, Your Honor.
All right. All right, I found probable cause. I've set bond. Good luck to you, sir. Again, your case will be coming up. If they choose to file in court and the division judge, you can make your argument for suppression of evidence and make those arguments in front of the division judge. Thank you. And good luck. All right, we're ready to get back to, is this Miss Ritchie?
Yes, sir. Present
Oh.
before the court, Your Honor.
Okay. And she was possession of controlled substance out on probationary bond. All right, possession of cocaine. Any argument as to probable cause?
No, Your Honor. Argument as to the request of bond. If I may be heard.
Hold on a second.
Of course.
Probable cause. That's the one. But she's not, isn't she out on bond?
No, Judge, not in what I'm reviewing, and she does not have any violent priors. I was gonna ask for pretrial services alternate 2,500.
But she said she's out on probation.
Judge, I don't have it. I'm looking at her prior history and I don't have any.
I have
probation
it
case.
here. It says probation case number F25-13574. It says out on probation. Let's see. Cocaine possession.
No, it's with the end date of 8/9/2025, Judge.
Yeah, I looked at that. I wasn't. So is this the same case or?
I'm looking at the clerks right now.
1-day probation, Your Honor, and then was rearrested the same day.
So it's a violation? Or?
When was it resolved state? I can't, can you speak into
It
the
says-
mic state?
It says the close date on this case was 8/8/2025. It ends 8/9/2025, and she got arrested on 8/8. So she seemed like she went right back out and continued to do the same thing that she was already getting a conditional probation for. So. And so is there no bond on that case or is it closed?
I would argue that it's closed.
Yeah, according to our system, Your Honor, is she got put on the probation, I was immediately rearrested, so technically she.
I still can't hear the state.
No, this was.
It's the court.
The court. They were saying that she was put on probation for 1 day, but she almost immediately got arrested. So, I mean, I don't see, I guess there's no violation filed, but there could possibly be a violation filed.
Being as her last day of probation was today and she was arrested yesterday, it would be a violation of probation. It's
And
the
I'm,
weekend, so it's likely not filed.
and
But
pretrial is not taking her, correct? All right, so pretrial is not taking her.
the state would ask for standard
Okay, what's the standard bond?
2,500.
All right, 2,500, but is she being held on a no bond for the probation? Okay,
Judge, are we getting appointed on the alleged violation of probation?
yes, yes.
Yeah, he just issued a hold.
And
Hold on, which case, Judge? Can I have the case number, please?
25-13574.
F25-13574.
Correct.
Thank you.
Now, Madam Clerk, is that gonna be said in,
Yes, Your Honor, you said in front of.
June Monday.
Yeah, at 9 a.m.
okay. All right, so then there's no bond on that case, because it's probation. All right, good luck, ma'am. This Miss Wells,
No, that was a bond out. We're on number 3, Judge. Jayla Wells was a bond out.
okay, hold on. Let's see what's on this.
Oh, if you could write on the back of the first page, bond out or BO and sign. Thank you, Your Honor.
Do I need to sign anything else on that?
That's why we have this here, count 1, count 2, count 3.
Oh.
You just have to write the amount, you have to write the whole thing.
All right. All right, so we're here, this is Miss James?
That's correct, Judge.
Okay.
I have probable cause argument, Your Honor, when you're ready.
And she's
Okay.
out on felony bond on 3 cases, Judge.
That's correct.
Hmm. And this is a grand theft, 3rd degree. All right, as to the grand theft, what?
Yes, Your Honor. The 4 corners of the arrest form indicate that this is a co-defendant case. There's no indication as to what the police observed allegedly Miss James doing as to the acting in concert allegation. Furthermore, the 4 corners of the arrest form do not indicate or reflect that she was found with any of the alleged property on her person or near her person, Judge. So I'm asking that this court release her outright, given the fact that the 4 corners of the arrest form failed to indicate that.
State?
Yes, Your Honor, in the arrest affidavit, it says that the defendant and co-defendant were working in concert while inside of the store, selecting multiple items from the shelves. Both defendants bypassed all points of sale without making any attempts to pay for the selected items and exited the store. The total value of all items stolen was $1,520.70, which indicates that they were working in concert, although it doesn't say that one person individually had a certain amount on them and the other person did as well. Them working together, the amount would be for the both of them, amongst the both of them.
All right, court finds probable cause for the grand theft. Okay, and as far as bond, this is
I was asking for standard bond, Judge.
just 2,500?
That's correct.
Okay,
Your Honor, the defendant has currently 2 grand thefts open, aside from this case, as well as a robbery, a strong arm robbery. The state would be asking for, well, first a felony hold and then secondary, we have for an elevated bond. And she also has a petty theft open. So it'd be asking for an elevated bond of 3,500.
I'll leave the standard bond and I'll find the felony hold on these other cases. Four. And stay away from colds. All right, good luck, ma'am.
Bond 2,500 with the holes.
Yes.
Thank you.
You can go, ma'am.
Is this Kendrick Mincy?
That's correct.
Okay. Charged with assault, aggravated assault with deadly weapon, battery by strangulation. Give me a moment.
It's an added charge.
So he was already out on bond or?
He's already in custody. They added this charge while in custody.
Okay,
And
gotcha.
the way that this reads is May 5th. I need to pull the arrest forms for the previous cases. So I understand that it reads as an added charge and maybe a delayed arrest, given the 2 cases that he already has open, Judge, and was on house arrest for. So
Hold on for a second. Let me connect Pearl to Cruz. All right.
I'm sorry,
Davis,
this is
Maria
Rico.
Victim.
What is the name of our felony clerk today?
It's Ashley Fernandez.
Thank you so much. Corrections was asking. I'm sorry for interrupting.
Thank you.
Okay, so as to the so I have in front of me, I read the aggravated assault with a deadly weapon and strangulation, but then he has an additional charge of escape.
And what I was citing, Judge, is that the arrest form that the court has in front of right now, the F-25-17070, the date
Right.
of that is May 5th.
Okay.
The previous cases that he has, F-25-15512, looking at the arrest form, that's a date out of July 18, 2025. The next case, F-25-13009, is a date out of June 23rd, 2025. So this allegation would be a delayed arrest. So I'm asking that this court does not place a no bond hold on the two other ones on the allegation that he committed a new offense while out on house arrest. As this arrest form in front of all of the parties here today was before the two arrest forms that have already been dropped on him and he was on house arrest for, Judge.
Yes, Your Honor. Just one moment.
No. And so, but there's no argument as to probable cause as to the two counts here.
That's correct, Judge. Not at this time.
Your Honor, the state would have no problem not putting a felony hold because this state of incident was prior to the others.
Okay.
Just one moment.
Would Your Honor consider reissuing the house arrest that he had previously, since the division judge heard the arguments for that and granted it? And
No.
this is again a date of May 2025, and the arrest that the court had was the June and the July dates when he granted or she granted house arrest. Judge Opfield.
Your Honor, the state would object to that.
I mean, he's got pretty lengthy priors and a lot of
Many of them are violent.
violent offenses. So
Judge De La O had that information when the bond was modified, Judge, and that's the division judge.
Okay.
Your Honor, I'm sorry for interjecting again. This is video. I have a Shatavis Riggs raising their hand on Zoom. I'm not sure if this person is here for this case.
It may be the victim. I see the victim Riggs.
Okay, I'll allow Riggs to talk then.
Your Honor, yes, I believe that would be the victim in the case.
Miss Riggs?
Yes.
What do you wanna tell the court this morning?
I just wanted to say that I didn't want to press any charges. It was just a misunderstanding between him and I with that case.
Given that information, I'm asking this court release him outright.
Your Honor, the state would still ask that Your Honor implement at least standard bond in this case, being as it was a violent offense. He does have other violent offenses open and he has been convicted of previous prior offenses. In working the case, allow the state the opportunity to speak with the victim privately in order to investigate the case further. And ultimately, if that is her wish, then we would act accordingly in proceedings. But at this moment in time, it is first setting, and we would like the opportunity to have a victim witness coordinator speak with the victim.
I mean, in their A form, it indicates that the victim said she wanted to press charges at the time. So I have some concerns about Mr. Mincy and his propensity for violence. So I'll remain with the probable cause, and we'll just set standard bonds on count 1 and count 2. And is it 5,000?
Yes, Your Honor.
All right.
Judge, would you consider reducing it to 2,500? Considering the fact that, again, Judge already in division, heard the argument, saw the priors, granted house arrest.
No, I'll leave it at that. It can always, again, go back to division where you can have a more lengthy hearing. The state will have an opportunity if Mr. Riggs wants to be there, and they can, and they'll be in a better position if they feel as if at that time they're convinced that he's less of a danger and reduce the bond. But at this time, I don't have that feeling. So I'm gonna leave
Judge-
them at the amounts that I've indicated.
Right, but then that means since the state agreed with defense and did not move for a hold on the 2 cases, that then reinstates the house arrest to those previous cases because he doesn't have a hold, or it would be the alternate bond.
I'm not sure what you just.
He'll be going to the division court, Judge.
Okay. I don't understand the argument, I guess. I missed it.
Judge, if he tries to pay this bond for the $10,000 that you set, he has
Right.
2 cases that he was out on bond that they did not move for a hold because the case that's in front of us today is a May date and those other ones was already addressed by the court. Corrections is not going to release him when they see the 2 previous felonies. So I need this court to reissue the bond that was a house arrest, given the fact that they didn't move for the hold, or set a new bond so that he could be released on those 2 cases, Judge.
You can reinstate to the previous conditions.
Yeah.
Of those 2 cases.
But I'm not gonna do it. I'm gonna set the bond. You can go back to the division, and if the division judge wants to make the changes, then will be what happens.
Judge,
Okay.
but you're illegally holding him then. The state didn't
Then-
move for the hold on the
Sir,
fund.
ma'am, and make the argument to the division. It's going back to division on Monday? Yeah.
Over defense's objection. You can go, sir.
Okay.
Talk to your-
Your objection is noted.
I don't got that.
All right, is this Mr. Leggett?
Yes, he's present before the court.
Okay.
Just don't worry. Let me make the argument and I have argument for probable cause.
Okay, give me just a moment. Shoplifting from the scene packing 10 single cans of Raid ant and roach spray. 8 packs of underwear and t-shirts. All right, as to probable cause, your argument?
Your arrest warrant 4 corners does not indicate the prior conviction to be verified as the statute requires when there is an allegation of a prior conviction in terms of retail theft, Judge. I'm asking that based on that, you find that there's not a felony, but find that there's a petty theft misdemeanor.
State?
Here, the April alone indicates the prior convictions. If I can inquire further from counsel, if they're mentioning that it doesn't attach fingerprints or anything of the sort, what do you mean exactly?
Does the state see a case number on the arrest form?
It does mention the date, although not
Good.
mentioning.
A case number, correct? Okay. So Judge, I also don't see a case number. That's what.
You're gonna have to take it out 1 moment.
Let's see. I'm looking at his priors. The last petty theft was 2017, 2016.
Judge, for bond hearing purposes, it's the 4 corners of the arrest form. The officer would have had to write that in the arrest form, and that's my position.
Your Honor, the state is just briefly overlooking the statute and he's charged with subsection 9A. Subsection 9A says, except as provided in subsection 11, a person commits a felony of the second degree punishable, violates, one second. Has been previously convicted of a violation of subsection 8, and subsection 8 doesn't indicate anything necessarily that would indicate that it would have to be the actual arrest or the actual case number enumerated in the A form. The A form itself alone mentions that he was trespassed on those dates and he was previously arrested on those dates. But I don't see anywhere in the statute that it says it has to have the exact case, no court case number or police case number of that. I know that during proceedings, it may be an issue as far as convictions, because I do know that they get fingerprinted when it's an enhanceable offense. However, for purposes of this hearing, I don't believe that's a requirement.
What does it say? Let's see, to the defendant was detained, arrested, and transferred. Yeah. But I don't see any A form where they ever talked about any priors, unless I'm missing it.
I believe it's on the second page.
Let me see. I go. Defendant was detained and arrested for trespass after warning that was issued on February 28, 2025, and was arrested on February 23rd, 2025 from the same location. It doesn't make any mention of prior petty theft or retail theft. All right, I mean, I'll find probable cause for the retail theft, no prior convictions. All right. And for the trespass after warning.
Would you consider releasing him to TAP?
Would pretrial take him?
No, Judge, he's homeless.
Okay. Yeah, can I release him and then have him go to the homeless calendar?
Yes, sir.
All right, so what do I do here? App.
Judge, we don't have, I don't know particularly Judge Block, but my judge, Judge Alfield, we don't have homeless calendar, so it would have to just be a date certain
that's-
he receives
okay.
today.
Maybe homeless for just for misdemeanors.
Yes.
All right. To the TAP, an alternate bond. $150.
Each count?
Yeah, on each count.
150 on each count, Judge?
Yes, as alternate bond.
And are you giving,
And a stay away from the Walmart.
are you giving him a date certain, Judge?
Do they give?
Yes, it will be September 8th. Is the arraignment date.
Okay.
Reset September, April. I see, because he's homeless. But do we know what courtroom or anything, or just?
And yes, Judge Lot, courtroom. 3-4.
3-4, and at what time? So again, 9/8, sir, at 9 a.m. Richard Gerstein Justice Building, courtroom 3-4 at 9 a.m. All right, good luck to you, sir.
Just call the office. TAP, alternate 100, 300. So you can go.
All right, who do we have here? This,
Mr. Bailey, page, no, well,
Okay.
number 7, Judge,
okay, I got it here.
present before the court.
Okay, he's charged with burglary, criminal mischief, petty theft. Let me see.
I have no argument, Judge, as to the three cases.
Okay,
He's
all right,
also
so,
a fugitive from Orange County, Florida, Judge.
all right, so there's no argument, court finds probable cause. Counts.
And Judge, as to bond, he doesn't have any violent priors in what I reviewed. I was not aware of the fugitive. I was going to ask for pretrial services alternate 2,500 on the felony third degree cases, as there's no violence alleged.
Right, but if he got I guess a fugitive, in-state fugitive, the pretrial's not gonna take him, correct?
No.
Right.
So
Okay,
I'm asking then for the reduced monetary amount.
all right, as to, what's the standard bond as to burglary? Count one?
It's to be said, Judge,
It says to be set.
that, right, and
Your Honor,
since,
the state would be asking for 2,500.
that's what I'm asking, Judge.
Hold on. The 2,500?
Yes, Your Honor.
All right, that's the count one. As to count two.
Case you're addressing, Judge, he has three cases.
Yes.
He's got three counts, or he's got,
Three cases, 3 counts each case.
geez. Okay,
Well, the state's position would be on each of the burglaries 2,500, and then, or does Your Honor prefer to go one by one? Okay, so for case F 25-017-038, the state would on count one, the burglary would be asking for 2,500, for the crime miss standard 500, and for petty theft standard 150.
okay.
And then for case number F 25-017-039, they would be asking for 2,500 on the burglary, standard 2,500 on the grand theft, and standard 150 on the crime miss.
Hold, let's just make sure I got. And this would be, I'm set. It is. Which would be, which would correspond to which case number? Okay. And so, what was the first case? To make sure I wrote this all down right.
First one was 17038.
See, I was all wrong. Okay. Okay, 1073,
17038.
Okay, so that one was 2,500 on count one. All right. 500 on count two. And then 150 on count three.
Yeah.
Okay. And then this one, I'm just going. This one is 125-17039. So PC. And on count one, so 2,500.
Yes, Your Honor.
Count two.
2,500.
2,500. And count three.
150.
50. And then this one would be 25-17040. And for count one, 2,500.
Yes.
Count two. Okay.
And count three, 150.
Okay, I think I got it all now. Okay, and a stay away order from the locations. I think so. All right, thank you. Good luck, sir. Is this Mr. Adams?
Yes, sir.
All right, unit finishing for emergency. The aggravated assault on a police officer. Contact.
No PC argument from the defense.
Okay, after all the cases, the ag assault and the petty theft?
I was gonna, no argument for probable cause. I was gonna ask for the assault to be set a monetary reduced bond, judge, of $3,750 as opposed to the $7,500.
And state? He's out. Now he's got a previous battery on a Leo, 2024 resistant.
Your Honor,
Right.
it
Okay,
would
good.
not necessarily respond to considering that have a previous violent offense against a law enforcement officer. We would actually be asking for
State, I'm sorry, can you talk into the mic if possible? You sound
I
very
apologize.
faint and distant.
I apologize. Being as there has been a previous violent offense against a law enforcement officer, the state would not be in agreement with a reduced bond amount. We would ask for a bond of $7,500.
All right, as to case F 25-17044, which is the resisting, or I guess aggravated assault on law enforcement officer, fine probable cause, set the bond at 5,000. As to the other two cases, this is this.
Yeah, this case is standard of 2,500.
All right. So in case F 25-17045, court finds probable cause set bond at 2,500. And then the third one, F 25-17047. Court does find probable cause set bond at 2,500. All right, good luck, sir.
Your Honor, I apologize. Never mind.
Oh, and a stay away order, of course, from the locations.
He's coming back, judge. Póngase ahí, por favor, señor. Judge, he's present.
All right, this in addition to the bond, is also a stay away order from the locations there in Midtown.
Yes, sir.
Okay, good luck to you, sir. Is this Mr. Nunez Castellanos?
That's correct, with the services of the Spanish interpreter.
Okay. All right, any argument as to probable cause?
Yes, Judge. May I be heard?
Yes.
In terms of the
Después de preguntar la defensora si hay argumento para motivo fundado. A continuación, la abogada defensora va a presentar argumento.
Yes, Judge. Nothing on the arrest form indicates that this individual cannot possess any firearms or weapons or transport them within the state of Florida. There are some statutes that permit the transport. I'll stop for the interpreter.
Thank you, counsel. Entonces dice la abogada que nada dentro del informe del arresto contiene nada que indique que dentro del estado de la Florida no se pueda transportar algún tipo de armamento. Continue, counsel. Thank you.
He doesn't have any prior, in the four corners of the arrest form, it doesn't indicate he has an injunction, he's violating a court order that says he cannot have a firearm, or that he's a convicted juvenile, delinquent, or convicted felon.
Y tampoco en el informe del arresto indica que haya algún tipo de interdicto que evite o que le impida más bien que pueda portar un arma. Tampoco hay nada que indique que él tenga algún tipo de fallo inculpatorio del pasado, bien sea como juvenil o que tenga simplemente algún fallo inculpatorio.
Furthermore, in terms of the alleged stock that's attached to the rifle, this issue has been litigated, and this morning I'll just place my citation on the record. It's Garland versus Cargill. It's a US Supreme Court case 602/2024. Judge, that the issue of stocks and bump stocks is being litigated at this time, Judge. So that would mean that there's also indication that the Florida laws and regulations should change given the fact and the findings of that Supreme Court case, Judge.
La abogada acaba de presentar un argumento que tiene que ver con jurisprudencia y cómo el estatuto de la ley pudiera ser cambiado dado a un breve cambio que ha habido en la ley.
Furthermore, in terms of the alleged, one second, Judge, there's indication that there was multiple people in this vehicle. There's a constructive possession argument where it isn't established if the officers saw who put it in the car or packed the car or manipulate the alleged firearms and the alleged controlled substances that are mentioned and cited in this arrest form, Judge.
También la abogada dice que había varias personas o varios ocupantes dentro del vehículo, entonces presenta el argumento en cuanto a si el oficial que condujo al arresto, de hecho, pudo ver bien sea armas de fuego o algún tipo de sustancia regulada dentro del vehículo.
There is self-serving hearsay that Mr. Robina is alleged to have said, Judge, but he also gets arrested. So that's self-serving. There's nothing that the police says that they saw themselves.
No hay nada que haya dicho, de hecho, que la policía como tal fueron quienes hayan observado lo que se alega.
State.
Yes, Your Honor. As to the first count of the possession of the short barrel shotgun, the statute itself doesn't indicate that any of the previously stated factors need to be present, only so that that gun is readily be made. It is unlawful for any person to own or to have in his or her care, custody, possession, or control any short-barreled rifle, short-barreled shotgun, or machine gun, which is or may be readily made, operable, and indicated in the arrest form. It does say that. The state at this moment in time would have no argument to count 2 of the possession of the weapon, being as it was not or does not appear as to the arrest form being displayed. And it also, or if Your Honor could just give one moment.
La fiscal presenta argumentos en cuanto a que sea motivo fundado para el cargo número 1 y en cuanto al segundo cargo no presenta mayor argumento en lo que tiene que ver con lo que aparece en el informe del arresto.
Being at this, they would have no argument as to the second one, being as there's no indications of use of it while committing the felonies. However, as to the words in the A form, it does say that the weapon was readily accessible to the defendant in this case, so the state would stand on the argument that there is probable cause.
La fiscal dice que no hay argumento para el segundo cargo, pero sí pide que haya motivo fundado porque no hay, porque el arma estaba accesible o el acusado tenía acceso fácil al arma.
And so you're saying that he's possessing it in commission of an offense, which is the possession of the short barrel shotgun.
Yeah.
Okay.
Está hablando de nuevo, ratificando argumentos, lo que tiene que ver con la tenencia del arma.
All right. Court will find probable cause as to all accounts.
Este despacho haya motivo fundado para todos los cargos.
As to bond, as to count one, any arguments?
¿Algún argumento lo que tiene que ver con el cargo número 1?
He doesn't have any violent priors. He doesn't have anything that prevents him from transporting and I should have mentioned this before, but the House Bill 543/2023 allows the transport of weapons in the state of Florida. There's nothing again indicating that, Judge. I'm asking this court. Do pretrial services with an alternate reduced monetary bond of 2,500.
La defensa está diciendo de nuevo que no hay nada que evite o impida que una persona pueda transportar armas dentro del estado de la Florida. Está pidiendo, de hecho, el servicio previo alterno y como alternativa una fianza reducida a $2,500.
The state would ask for standard on each count.
La fiscalía está pidiendo la fianza estándar para cada cargo.
The first count is to be set by your honor. Typical standard or previously set standard was 7,500 on that count.
Para el primer cargo, la fianza estándar sería 7,500.
All right, as to count one, court will set bond at 5,000, count two, 2,500, count three, 2,500, and count four, 500.
Entonces, este despacho fijará la fianza. El primer cargo a 5,000, el segundo a 2,500, el tercero a 2,500, el cuarto a 500.
All right, good luck to you, sir.
That's straight bond or pretrial services?
No, there's no pretrial services in this
Thank
case.
The next one is with the interpreter. Póngase en esta caja.
This is Mr. Morella Rodriguez.
Varela Rodríguez.
Present before the court. Judge, I only have argument as to count two.
La abogada defensora solamente tiene argumento en cuanto al segundo cargo.
Okay, as to arguing state probable cause. They're saying that, I guess the defense said no argument as to count one possession of cocaine, but the argument as to count two. What's the argument?
Judge, in the state of Florida, state hemp is legal. There's nothing that indicates that these officers tested to be able to establish in the four corners of the arrest form that it was an active illegal THC strain. We also have the medical marijuana statute as well. So for those reasons, I'm asking this court find that there's no PC on that count two, release him outright.
La defensora no tiene argumento para el primer cargo que tiene que ver con tenencia de cocaína. Para el segundo se dice que no hay nada ilegal con que pueda tener el cargo, lo que se alega en el segundo cargo. Entonces está pidiendo que se le dé un escarcelamiento directo.
State.
Yes, Your Honor. Being as this is first setting, the testing and the further investigation into testing what type of strain it may be would be for later investigation from the officers. As to the four corners of the arrest form, it does indicate that they found the marijuana grinder, that it contained loose marijuana in it. That marijuana residue was 0.1 grams, which is less than the 20 grams, and the charge that he's being charged. I apologize.
It's okay. En cuanto a lo que tiene que ver con las pruebas que hizo, según lo que aparece el informe del arresto, lo que se halló como restos de marihuana y lo que tiene que ver con el proceso que se le había hecho, conduce a que sí había marihuana en el individuo y me continue usted, thank you.
So the charge that he's being charged with is possessing 20 grams or less, and that is what is indicated on the arrest affidavit.
Y el cargo de que se le imputa, que es por tener 20 gramos o menos, es lo que aparece en el informe del arresto.
The state would have no objection to RORing him on that charge, but would be asking for standard bond on the others.
Entonces, para el primer cargo, para ese cargo no tiene inconveniente que se le dé libertad bajo palabra, pero se está pidiendo la fianza estándar para los otros.
All right, court will find probable cause as to all counts. Bond set as to count one, 2,500, count two, RR, and count 3 RR.
Entonces el juez el juez sí haya motivo fundado para todos los cargos. Para el primero impone fianza de 2.500, para el segundo libertad bajo palabra y para el tercero libertad bajo palabra.
All right, good luck to you, sir.
Would
Buenas
Your
Yes,
Honor,
counsel.
would Your Honor consider pretrial services as an alternate? He doesn't have any violent priors.
La defensa está pidiendo el servicio previo al juicio, dado que no tiene antecedentes penales que involucren violencia.
All right, pretrial services said they will take them, so I'll
El servicio previo al juicio dice que si lo va a aceptar, entonces se aprueba.
Right, PTS alt at the very top.
Okay.
That would be nice.
All right, so it'll be pretrial services, so you're gonna get out. Remember to follow the direction of pretrial services, alternate bond, 2,500 on count 1.
Entonces, le pruebo para que lo van a poner en libertad, para que vaya al servicio previo al juicio. Tiene que seguir las instrucciones o directrices que leen allí como alternativa, 2.500 de fianza.
Se puede retirar. Sí, se puede retirar. Tranquilo. Gracias, señor. Que tenga buen día.
Next, we have Gabriel Rodriguez.
Face that way. Present before the court, Judge. I have argument.
All right, let me read the 8 form. All right, argument as to probable cause.
Judge, there's no, on the four corners of the arrest form, there's no probable cause for the petty theft 2 or more convictions. There is a date that's stated, but there's nothing that mentions the cases that they're relying upon, and the four corners is my position that should have included any case number. So for that reason, I'm asking that this court find that there's only probable cause for a misdemeanor and not a felony 2 or more convictions.
State.
Yes, Your Honor. It is still the state's position that the actual case number itself does not need to be mentioned. However, it is indicated here that he on 1/27/2025 was convicted of petty theft 2nd conviction. So it would be reasonable to assume that if he was convicted of his petty theft 2nd conviction, that this one would be 2nd petty theft 2 or more convictions.
All right, court finds probable cause, petty theft prior convictions. That's
Would you consider releasing him to TAP? He's homeless.
yes, the court, the state, any objection?
Will TAP take him?
Well,
Oh, I'm not sure. No objection.
because I don't know if they take him. If he's homeless, he's not gonna have an address. How do they contact him?
TAP takes homeless individuals, Judge.
I'm just not sure if the priors were an issue with it.
Okay,
But
it's all,
It doesn't have any violent ones.
all right, tap alternate bond, 1,000.
Good luck, sir. Is there anything else with this individual, Judge, before I release him?
And to stay away from the target.
We don't number 13. Judge, we're calling number 13 at the corrections, let me know. And just before there's any readings of the charges, I'm waiving the reading of the charges on the record. I only received the warrant. I don't have the actual text and language that was used by the state to apply for the warrant, Judge. So I'm limited in the arguments that I can make. And I also try to check the clerk this morning, the docket, it doesn't have the file itself. I just asked that the allegations aren't talked about on the record.
Okay.
He needs the services of the Spanish interpreter, Judge. I apologize.
Got it. Thank you.
To confirm, this is Jackie Glisson, right?
No.
Oh,
Number 13, state.
This is William De Jesus Martinez Linares.
William de Jesus Martínez.
George, you call him Martinez, Linares?
You guys
Is
asked
that-
for number 13.
Yes, I'm asking a question. He has an immigration hold. Jesus Christ.
But this is William De Jesus Martinez Linares, correct?
Es William de Jesús. Están tratando el caso de William de Jesús Martínez Linares.
Yes.
Yes. She's
May I inquire if the court is reviewing the warrant?
I am.
El juez está revisando la orden de arresto.
That has a narrative, correct, Judge?
Yes, it does.
I'll rely on the court's rating of it since I have the limitation of not having it. If the state could send it via email to me really briefly, I would also appreciate that, but I know that we're moving at a fast pace, so I don't know if it's possible.
the state also only has the bench warrant or the.
Understood, understood. Thank you.
Okay. All right, court does find probable cause based upon the reading.
A la luz de lo que se acaba de leer en el informe del arresto, hallo que hay motivo fundado.
Are you entering the bond amount that's on the warrant arrest form, Judge?
Yeah, it was set at 50,000.
Dejaremos la fianza a $50,000, que es lo que aparece según el informe de la orden de arresto.
Doesn't mention anything about stay away from the victim, but I would add that it should be a stay away from the victim in this case.
Yes.
No hay nada que indique acerca de una orden de alejamiento de la víctima, pero debería haberlo, dice el juez.
Your Honor, at this moment in time, state does not have the name of the victim because we only have the warrant affidavit.
It would, he wouldn't like.
La fiscalía todavía no tiene el nombre de la víctima, solamente el informe que aparece en la orden de arresto.
Corrections, I just wanted to confirm that defendant has an ICE hold, correct?
Yes.
Están verificando, este acusado tiene una orden migratoria de retención. Una orden de retención migratoria, más bien.
All right, good luck, sir.
Buena suerte, señor.
Puede retirar. 12.
And it's Mr. Gleason.
That's
Yes,
correct.
sir.
Yes.
Okay.
Judge, I have arguments similar to my previous ones with the petty theft, 2 or more convictions.
And whenever your honor is ready, the state may respond.
All right, any argument as to probable cause?
Yes, Judge, there's only argument, in terms of the 4 corners of the arrest form, there's no mention of the actual cases that the police is relying upon, whether it be a B-24 or a F number. So I'm asking this court find that there's only misdemeanor petty theft and not petty theft 2 or more convictions.
The state would remain on the position that the actual case number need not be mentioned. It does indicate in the arrest affidavit that the defendant had 2 previous petty theft convictions.
All right, court finds probable cause as to the petty theft prior convictions.
The state would just ask for standard in this case.
Judge, he doesn't have any violent priors. I was gonna ask if possible, if he qualifies for pretrial services alternate 2,500.
Pretrial is not gonna take them, sorry. All right, so probable cause bond, 2,500. And a stay away from the Walmart, 1425 Northeast 163rd Street.
Yes, sir.
Good luck, sir.
No.
All right.
We're on number 14.
This is Jerry Zagradano.
Yes, sir.
Present
Okay.
before the court.
All right. Let me read this.
Judge, I could tell the court, I don't have argument as to F-25-17060. I do have argument as to F-25-17059.
The cannabis. Okay. Hold
Yes,
on.
Judge.
All right, state any argument as to, I guess, the cannabis possession? Go ahead. I have that one. Oh.
Yes,
Okay.
ASA Joshua David on behalf of the record.
Hold on, I didn't realize there was a second A form.
Yes, on the cannabis possession, this was an inventory search, so pursuant to the exception that once you impound a car, you can conduct a search, that they found the marijuana. So
All right, so court.
Judge, may I preserve my arguments before the court rules?
Absolutely.
In terms of the state of Florida cannabis, the officers, even in depositions, could testify that they cannot differentiate between hemp, Delta 8, Delta 9, or active THC and medical marijuana. Given that there's nothing that establishes that the 4 corners does prove that it's actual cannabis in the statute that makes it illegal, I'm asking that this court find that there's no PC.
Okay, so noted. So as to case F-25-17060, which is the domestic violence, written threats to kill. Court does find probable cause. Any argument as to bond?
Gonna just ask for $1,000 on the written threats and $500 standard bond on the battery domestic violence.
I'll set count one at 1,500. And set count two at 500. As to the cannabis, the court does find probable cause. And set the bond at 500.
But he's gonna need permission to return to the property once released to get whatever items he has. May the court enter that now?
They gave me actually a non-domestic stay away order. No, it does say battery domestic violence. It should have came up earlier. I'm gonna need a domestic violence. All right. I have the form.
We don't have any in here, so we have because it's not the regular.
If I don't do it, they're gonna. Well, if you are released because they're related as domestic violence, I believe it's additional terms is you cannot commit any crimes, no possession of alcohol, you cannot possess any guns, ammunitions, or firearms. If you do possess such items, you have to turn those in within 24 hours of your release. You have no contact with the victim in this case. No contact means not in person or through text messages, emails, third parties, or any other electronic devices. If you were cohabitating, you would be allowed to visit the property one time within 24 hours of your release. You must have an officer with you. At the time, you're only there to receive your personal items, any medical items, any work items or work tools. If you are at the house without an officer or remain when the officer is not there, you will be subject to arrest. And you stay 500 feet away from the victim, where she works at, and any school that she attends. I guess as soon as they can provide one to me, I'll be happy to sign it, but put that on the record.
We can move on.
Okay. All right, thank you. Good luck to you, sir.
Thank you.
Hope I got all
They're
that right.
calling somebody out of turn, specifically number 23.
And
And I see that this was a reset from yesterday. For hearing, Judge,
okay, they're getting the paperwork for me.
of course.
This is on then, right?
On 10. Yeah, the reset from yesterday.
All right, so Luis Garado Thin. Trespass and criminal mischief.
No, these are added charges. The
Oh,
felony.
battery by detainee?
Yes,
Okay,
2 cases.
okay. All right, let me see. All right, so this read the eighth form 125-16991. And the other case is 25-17010. Let me read that one. Any argument as to probable cause?
Judge, the one that was reset from yesterday, 520, F25-17-010, that indicates that the alleged victim does not want to press charges. My understanding is that it was reset for argument today. But I would rely on that just and the fact that the individual said that they do not wish to press charges. Ask that the court find that there's no PC in that case and no argument as to F25-16991.
All right, so state as to.
The
Do you
state
have
will
questions
to
for me?
investigate those things. We were on the record yesterday, we would have to dismiss, but if they're not, we would just ask to set standard bonds of 5,000 on each account, so as we can investigate whether these are police. You know,
State, I need you to speak into the microphone. I didn't hear anything, Judge.
Okay. State would ask that we set standard bonds of 5,000 on each. If the victims claim they do not want to proceed, it's up. The state can diligently investigate over the next couple weeks, and we just respectfully ask that he set $5,000 bond. This is a battery on detainee. It's not like he's going to be released.
Well, as to 25-17010, and here, I mean, the victim refused to provide a statement and didn't wish to press charges. So I'll find no PC as to that case.
Release outright.
Yes. And on second one, F25-16991, court does find probable cause. And set bond at 1,500. All right, good luck, sir. This Mr. Addison?
That's correct, Judge.
Judge, he's out on probation, F12-18424.
Judge, that pled out on 3/17/2014 to withhold 1 day. It should be resolved. I looked it up this morning. And it does say that they didn't, the clerk didn't receive a score sheet, so I don't know if that's why it still reflects as open, but I checked this morning.
Well, it said it was the 1 day and it ended on March 18th.
March 17th, 2014, Your Honor.
Right. But the probation ended. It says 2104, so you'd be on probation for a long time. Yeah. All right, but as far as the possession of cocaine.
No argument, Judge.
All right, court finds probable cause.
They will be asking for a standard bond of 25,500.
Judge, he doesn't have any violent priors. Would you consider TAP as an alternate?
Yeah, I'll consider TAP alternate bond 1,000. Yeah, no hold on the probation.
Right.
May I inquire from the clerk if there's anything that defense should do to ensure that that case no longer shows as open?
Contact the Division JA, and they would have to contact the calendar clerks to handle it.
Understood.
That would be- That is a calendar clerk system.
Is that tap?
I know who it was now.
Judge, my next person, number 16, is with the Spanish interpreter.
Okay.
Got it, thank you.
Estamos viendo si le van a dar una.
All right, any argument as to probable cause?
No argument, Judge.
All right.
La defensa, la abogada de la defensa no tiene ningún argumento en cuanto a motivo fundado.
The probable cause as to count 1 and count 2.
Hay motivo fundado para el primer cargo y el segundo también.
Would the court consider pretrial services alternate the monetary standard bond, Judge?
La defensa le pregunta al juez si pudiera tener en cuenta un servicio previo al juicio como alternativa para la fianza monetaria.
Would pretrial take them?
Pues, el juez pregunta si el servicio previo al juicio estaría dispuesto a aceptarlo.
Counsel, does your client have an address so the pretrial may consider taking him?
Yes, Judge, he does. It's the one that's reflected on the arrest form, 102 West 34th Street, Hialeah 33012.
El abogado confirma que la dirección es la del 102 en Hialeah, West Street en Hialeah.
So the court will be pretrial services, alternate bond 500.
Entonces, servicio previo al juicio como alternativa fianza de $500.
On what count? There's 2 counts.
That's so that possession of cocaine, pretrial services, ultimate bond 500, and the petty theft, the alternate bond is 150.
Entonces, para el primer cargo que tiene que ver con tenencia de cocaína, le admiten el servicio previo del juicio como alternativa 500. Para el segundo, por hurto menor, serían judgment pero 150 for the second one, right? Petty theft?
Correct.
Thank you, Judge. Y para el segundo cargo, el de hurto menor, 150.
Señor, tienes una fianza de $650, tienes que pagar el 10% y te puedes salir, o tienes que esperar a pretrial services. O pretrial services. O pretrial services. Sí, señor. Que tenga buen día. Hi, sir. Spanish or English?
Is this Jose Carlos Gerdo?
Yes, Judge, he's present before the court.
He's been held on 2 AC cases, no bond.
I don't have PC argument, Judge.
All right, so court finds peace, probable cause. Let's go there. All right, any argument as to bond? All right, as to possession of,
Judge, I'm asking if this court would set a reduced monetary bond on the F-25-17069, given the fact that he's being held on other cases.
you have to count one, set the bond at 1,000.
Is there anything else with this particular individual before I let him go?
No, I don't believe so. I think he's got the other two holds.
Okay. Spanish interpreter for our next. Hola, señor. Un momentito, por favor.
Mr. Pineda, Mr. Pineda Munoz has an immigration hold, Judge.
Señor Pineda Muñoz tiene una orden de retención de inmigración.
No argument, Judge.
La defensa no tiene argumento para motivo fundado.
We're gonna ask for the standard bond of 5,000 for the aggravated assault and 1,000 for the battery.
I'm sorry, 5,000 for the aggravated assault and how much for the battery?
1,000.
Got it, thank you. La fiscalía está pidiendo $5,000 de fianza para el cargo de intento de agresión con agravantes y para el caso de agresión física, 1,000 de fianza.
All right, so the court finding probable cause sets the bond in count one at 5,000, count two, 1,000.
Entonces el juez haya que hay motivo fundado para los cargos, $5,000 de fianza para el primero, 1,000 para el segundo.
And also a stay away order from the victim. Yes, counsel?
Y una orden de alejamiento de la víctima.
Would the court consider house arrest at this time?
He has the immigration hold, Your Honor.
Okay, okay, they won't take them. All right, thanks. Good luck, sir.
La defensa pidió arresto domiciliario, el juez la ha denegado.
Se puede retirar, señor. Hablé con el abogado en la semana para que pueda platicar más.
Next one is Mr. Williams.
Refuse, reset tomorrow, Judge?
Yes. All right, so we'll reset. All right, who do we have next?
We have Mr. James Skinner present before the court, number 21, Your Honor.
Okay.
And I have argument.
All right, driver license suspended habitual. All right, argument as to PC.
I apologize. I was muted. As to the habitual felony F3 that came in, the habitual offender status already lapsed in terms of his license, as it indicates 1/12/2011 and then 5/21/2015. The HTO period is only active for 5 years. So what this means is that this new DWLS should be coming in as a county misdemeanor DWLS because the HTO is not active. Does it print on the license? Yes. But the HTO status to be charged as a felony in the 3rd degree does not qualify if the suspension is inactive of the 5 years, Judge. It resets the clock, and I can represent to this court that before I was a PD, I was a traffic attorney working with Alex Hanna, and that's how I know this particular statute and the explanation for it. So it should be only a DWLS misdemeanor, not a F3 habitual offender, Judge.
No objection. It should
Alright.
be a county court.
All right, so no probable cause. DWLS habitual. DWLS, and what's the bond on that?
Be 150.
150?
150.
All right. So this probable cause has a driver license suspended, set the bond at $150. All right, good luck, sir.
Say it again, he didn't hear you.
Sir, thank you.
Okay.
Judge number 22 is NBC medical for COVID is what corrections is telling me. May that be reset?
That's Mr.
Valladares.
Valladares.
That's correct, Judge.
Okay. Got that tomorrow.
Courtney is we got Courtney as a one that on your top.
And Judge, we have Mr. Anderson, number 25, as number 24 was a bond out.
Wait a minute. So Ricardo Courtney is a bond out?
That's correct, Your Honor.
Okay. What else? Okay, and the next. So this is Mr. Anderson?
Yes, Judge.
That's
Okay.
correct, Judge.
All right, grand theft and says he's out on felony bonds. All right, any argument as to probable cause?
Yes, Your Honor. The way that the arrest form indicates, it doesn't specify whether Anderson or Thompson was the one that was seen either acting in concert or taking the items and putting them in the car. The Four Corners does not indicate that. Furthermore, it doesn't indicate who was pushing the alleged cart at the time to have shown possession of the items. For those reasons, Judge, I'm asking that this court find that there's no PC.
Hey.
While the A form does lack an extensive narrative of what happened, I believe there could be there's a good faith basis to believe that they were acting in concert here and acting together to
Yeah, I find probable cause. They both were principal in this endeavor. I don't think they have to both be walking out with the cart together. Anyway, so as to count one, the 2,500, and then he's out on felony bond.
Facing the hole.
Yes. And also stay away from the Home Depot. Good luck to you, sir.
Number 26 is a bond out.
This is Mr. Thompson.
That's correct, Judge. Bond out.
And this is Mr. Jean.
That's correct, Judge, present before the court.
Okay, burglary, occupied dwelling.
No argument.
Okay. Probable cause.
It's an added charge.
All right, any argument as to bond?
State's just going to ask for standard bond of 2,500.
All right, we'll set the bond at 2,500. And he has what, probation holds or? Okay. And also stay away from the location. All right, this Mr. West. All right.
Yes, Judge, he's present before the court, Mr. West.
All right, felony possession by a convicted felon. Any argument for probable cause?
Yes, Your Honor, the way that the arrest form reads, the four corners, I'm going to put in question, and I understand, but in terms of the arrest form and how it reads, when the warrant was served, there's no indication that Mr. West was allegedly in that south bedroom that the police is specifying that is his. I understand that they've mentioned some indication of items being there, but that doesn't establish that he either knew about the alleged firearms, the accessories of the weapons that was located. So for that reason, I'm asking that this court find that he didn't have either actual or constructive possession and find that there's no PC.
State.
The A form says that it was Mr. West's room, which all this was located in, and so I believe there is probable cause to find that these weapons were his. And if they are not, it's a matter for a jury to decide, and that's a factual issue that could be litigated another day.
All right, so the court finds probable cause. The search was based upon a warrant, which certainly would have had to have enough specificity to been signed by the judge, indicating what was being searched for and where it may be found and who was the subject of the search. The court does find probable cause as to, is it 2 counts?
Correct.
All right, no, both counts. And any argument as to bond?
I'm gonna ask for 5,000 on each count. He was just convicted of cocaine possession and tampering with evidence of June of this year.
Judge, I'm asking that given the fact that there's no violent priors, this court issue a reduced monetary amount or release him to house arrest. And just so I may inquire from my own records, did the court review the warrant?
No, I don't have the warrant before me.
Understood. Understood.
All right, he's got a. Finding proper cause in count 1, court sets the bond at 5,000. To count 2, court sets the bond at 5,000. All right, good luck to you, sir. All right, is this Mr.
Pinnacle, Dwayne, number
Pinnacle?
29.
Okay. Any argument as to probable cause?
No argument as to both cases, Your Honor.
Okay. All right, so finds probable cause. Go to case. F 25-17041. Any argument as to bond?
Are you inquiring from the state or the defense, Judge?
Either party can, at this
Your Honor.
point.
Okay, so defense is asking for a reduced monetary amount on the F2s. Well, rather, let me go in for the record. F 25-17041. On the F2, I'm asking this court set a $5,000 bond. Count 2 on that case would be $2,500, and then count 3, Judge, I'm asking this court to set a $7,500 bond, with the alternate being house arrest.
You're saying on this, on count 1, you're asking for how much?
5,000, Your Honor.
All right, any objection from the state?
Yes, the state's gonna object. The amounts he is being charged with are over 50,000 for one of them, and for both. For both. And so state's gonna ask for an elevated bond of 10,000 per each count.
All right, as to 25-17041, that's the count 1, court sets bond at 5,000. Count 2, 2,500. Count 3, 5,000. And then we go to the second one, which is hold on. F 25-17024. Look at that paper. Yeah. All right, court finds probable cause. Count 1 on it 2,500. Count 2, 2,500. Count 3, 5,000. And it's also a stay away from the state Space Coast Credit Union. They're on South Dixie Highway. All right, good luck to you, sir.
Judge, did you deny my request for house arrest?
Yes. I think.
Calderon. We're on number 30, Your Honor.
Is this Mr. Calderon Sanchez?
That's correct, Judge.
Yes, Your Honor.
Okay. Where's the? Battery by strangulation. Victims in a living relationship for the girlfriend. All right, any argument as to probable cause?
No argument.
Okay. Whatever report finds probable cause, all counts. As to bond,
State's gonna ask for 5,000 for count one, 2,500 for count two.
Judge, he doesn't have any violent priors. I was going to ask for a reduced monetary amount on the count one of 2,500 and count two of 3,750, which would be the half of the 7,500.
He might not have violent priors, but both of these charges are violent in nature.
Judge, and this is an allegation from May. There's nothing that's been alleged that there's been violent contact or violence towards this alleged victim since that date. So I would ask this court to also take that into consideration in terms of the bond.
and the fact that he sort of turned himself in, came to the police station, turned himself in, or at least went there. So, as to count one, 2,500 robbery, which is a snatching a cell phone, set at 1,500.
So, Judge, you're not finding robbery strong arm, you're finding robbery sudden snatch?
No, well,
Just
I mean,
verify it based on the language.
okay, I'll find the strong arm robbery.
What was count one, Judge?
The battery by strangulation. And 2,500. And it should be a domestic violence stay away. Know why? So again, if you're able to make bond, you have to stay away from the victim in this case. You can't commit any crimes. You can't possess any alcohol. You can't possess any firearms or ammunition. If you own such items, you have to turn those in within 24 hours. You did not live together, so you gotta stay 500 feet away from the victim, where she lives, where she works, and if she goes to school. But those are additional conditions of your bond if you are to be released, sir. In the
What was the bond on count two?
1,500.
Understood. Anything else with him, Judge?
No, and the state needs to provide a domestic stay away.
Filling it out now.
Okay. This is Wills Galindo.
Present before the court, Judge.
Dr. Ryer, all right. Let's see. Domestic violence. Our brothers reside together. Okay.
Conditions you do not want to apply, it's N next.
Okay, so back to Mr. Galindo, Willis Galindo. Any argument as to probable cause?
No argument, Your Honor. That's the probable cause at this time.
So on reviewing the priors. The state can stipulate to $2,500.
All right, now if they indicate that they're brothers, it's, it's filed as domestic. But assuming they don't live together, it looks like they're fighting over a business issue.
A form does say they reside together.
Oh, it does say that.
Well-
All right, so I need the domestic violence conditions, additional conditions. You have a. Okay.
Is that a non-domestic one?
Yes, it's not. And so if you are released, the conditional conditions are do not commit any crimes,
They're still right.
no excessive use of alcohol. You cannot own a firearm, weapon, or ammunition. And if you own any of those items, you have to turn those into the nearest police precinct within 24 hours of your release. You have to stay 500 feet away from the victim, where he works at, or in school. Since you both reside together. Right.
If you want to read the condition.
Yeah, okay. So do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearm, ammunition, and any concealed weapons permit to the nearest police department upon receipt. You prohibit having any direct or indirect contact with the victim in this case, which includes contact in person and writing, by telephone, through social media or other electronic means, or through third persons. You must stay at least 500 feet away from the victim in this case. Since you were living together now, you may only return to the resident one time only within 48 hours of the entry of this order, accompanied by a police officer, to receive personal clothing, personal health item, medication, personal and business-related paperwork and work tools. Going to the house or remaining at the house without the police will subject you to arrest. The officer shall request all keys and garage doors openers to the house from the defendant and return them to the victim.
What's the bottom amount, Judge?
Bond amount, did I set bond amount on this one yet?
No.
Probable cause. Let me see.
Judge, and I was gonna, he doesn't have any violent priors. Or any priors in Miami-Dade.
I'll set the bond at 1,500. All right, good luck to you, sir. All right, is this Mr. Jones, Claudius Jones?
Sir.
All right, good afternoon, sir. Let me read your A form here. Charged with aggravated battery.
No argument as to PC, Judge.
All right, court finds probable cause. Any argument as to bond?
Judge, he doesn't have any violent priors. I'm asking that this court set a reduced monetary amount of $5,000 as his release.
State's gonna ask for a $7,500 bond.
Into the mic, please.
The state's gonna ask for a $7,500 bond. He has a previous battery conviction.
Well, let's see, like in 2000, long time ago.
Judge, what was the bond amount?
I hadn't set one yet.
I apologize.
Okay. I'll set the bond at 1,500. And also a stay away order from the victim.
Spanish hearing? Oh, Spanish. Hola, buenas tardes, señor. Judge, this is the co-defendant for the short barrel that I argued earlier.
Correct.
I'm arguing that this also doesn't establish that he was in actual or constructive possession of any of the items in the way that the arrest form reads, Judge. So I'm asking that this court find no PC.
La abogada está pidiéndole al juez que no haya motivo fundado para el arresto a la luz de la manera como aparece el informe del arresto.
All right, court will find probable cause. Those counts. Any argument as to bond?
El juez halla que sí hay motivo fundado y está preguntando qué argumento habría en cuanto a fianza.
Judge, he doesn't have any violent priors. It seems like this is the first arrest locally. So I'm asking this court set a reduced monetary amount. Are you ready for me? Count 1, 5,000. Count 2, 1,500. Count 3, 1,500. Count 4, 250.
Dice la defensa, señoría, este acusado no tiene antecedentes penales que involucren violencia en el área local, por lo tanto, estamos pidiendo fianza reducida para el primer cargo, $5,000, para el segundo, 1,500, para el tercero, 1,500 y para el cuarto, 250.
No objection.
All right, so that's the count 1 bond will be 5,000. That's the possession of short barrel shotgun, the possession of a weapon. The count 2 would be 1,500. Cocaine possession, count 3, 1,500. And drug paraphernalia, 250.
Entonces, la fiscalía no tiene objeción, por tanto, en el primer cargo quedan 5,000 de fianza, en el segundo 1,500, en el tercero, que tiene que ver con tenencia de cocaína, 1,500, y en el cuarto, que es tenencia de parafernalia para drogas, 250.
All right, good luck to you, sir.
Buena suerte, señor.
All right.
Kevin Reyna was a bond out number 34.
Okay. What's the last one? Oh, or 2 more?
We're almost there, Judge. We're in Ferrera. He's present before the court. He speaks English.
Okay.
No argument asked to PC, Judge. We could set the bond.
It's an add
Okay.
charge.
Correct.
All right, any argument as to bond? Battery by detainee.
I'm just gonna ask for a reduced monetary bond of 1,500, Judge.
So ordered. Good luck to you, sir.
You can go.
What was the bond?
1,500.
Thank you.
Wasn't it Spanish hearing this? Judge, we have Mr. Mesa in front of the court.
All right. This is possession of controlled substance, cocaine and fentanyl.
No PC argument, Judge, from the defense.
All right, the court finds probable cause. PC, all counts.
As far as bond goes, Your Honor, this defendant was found, took a withhold adjudication on cocaine possession on April 9th this year. And a withhold on resisting without violence on April 9th this year. So we're just gonna ask for On counts 1 and 2, 2,500, and on count 3, 500.
Judge, defense was gonna ask, since it seems like he satisfied and completed probation successfully. And he doesn't have any violent priors indicated in the prior sheet. For pretrial services alternate, reduced monetary bond of count 1, 1,500, count 2, 1,500, count 3, 150.
Would pretrial take him? All right. We're releasing the pretrial services, alternate bond as to count 1, 1,500, count 2, 1,500, and count 3, 150.
You have pretrial services. If you, correct.
And also stay away from the Walmart.
Yeah.
Okay.
Judge, I believe that concludes all the cases.
Yay.
But let me
All right, thank you all.
just verify. Is there any other case number?
I don't think.
I had a reset for 8-9. I don't know. F25-16970. Let me just see.
I'm sorry, can you repeat the case number again?
Of course, F25-16970. I'm also gonna review if this was one of the people that got reset for another day as well. Just 1 second.
Yes, I see here that we reset him for tomorrow.
Perfect. Thank you so much. Thank you, everyone. Have a
Correction,
lovely.
Ashley, do you need anything from me?
Thank you.
Good afternoon, everyone. George Alejandro, nice working with you. Bye, all.
Bye.
Good afternoon, Your Honor.
All right.
Correction, do you need me to double check anything?
No, let me check the last two. 1 second. Don't go nowhere.
Okay.
Thank you. All right, thank you. You have my stamp and the thing. Oh, you. Okay. Yes. Say that like say.
Okay, everything is good. Thank you so much for waiting.
No problem.
Have a good day.
Recording stopped.